is 10 o'clock. I will go ahead and call this meeting to order. The chair notes that there is a quorum present. We'll start with the flag salute. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We took your comments under. Absolutely. Okay, first up is additions and revisions to the agenda. Commissioners, I need to poll under the consent agenda the 3 meeting minutes that are listed. Those will be coming up probably at a future meeting. For folks who are interested in seeing what happened during those meetings, those are all recorded. They're all on the county's website. So if you actually want to go see the video, those are up and you can access those. Okay, we're going to move into 3.0. Oh, commissioners, did you have anything else to add?
I do not.
Okay. 3.0 is a public hearing regarding ordinance number 2023-03, amending the Gilliam County zoning and land development ordinance to reduce property setback requirements in Article 4, sections 4.200 and 4.210, Condon urban growth area zones, UGA-C and UGA-C1, and adopting other implementing amendments. I have a whole script that Michelle did for me. Welcome. The public hearing today will be held according to the legislative public hearing process. This is the time duly set and advertised to conduct a public hearing to consider ordinance number 2023-03, text amendments to the Gilliam County zoning and land development ordinance, including Article 4, Section 4.200 and Section 4.210, Condon urban growth area zones, UGA-C and UGA-C1. Specifically proposed are amendments to reduce property setback requirements. The hearing is now called to order. The public hearing will be conducted as follows. Staff will give their report and answer any questions from members of the county court. Following the staff report, I will then open the hearing for public testimony. Beginning with proponent, opponent, neutral, and agency. After the opportunity for public testimony, members of the county court may have additional questions for staff. Then the county court will decide whether to close the hearing and deliberate the matter. Rules. Testimony. When you testify, please state your name and address for the record. We also have a sign-in sheet over on the table to make that a little easier for us to keep track. Please keep your testimony concise and relevant to the issues before us this morning. All testimony shall be directed towards the county court and not to other members of the audience. The applicable criteria are listed in the staff report. These are the criteria the county court will use to make its decision. Failure to raise an issue with sufficient specificity to afford the county court and all parties an opportunity to respond to an issue may preclude an appeal to the Land Use Board of Appeals based on that issue and may preclude an action in circuit court. To expedite the hearing, members of the county court may ask questions of persons as they testify. At this time, I ask the members of the county court to disclose any conflicts of interest or other matters that might preclude your participation in these proceedings. Please indicate the nature of the conflict and state whether you intend to participate in the proceedings. Does anybody have any conflicts that they wish to declare?
Do not.
Okay.
I suppose I should just, the fact that my 2 brothers are landowners with the urban growth boundary, but there's no financial impact to me, so.
Got it. Does anybody wish to challenge the ability of any member of the county court to participate in these proceedings? Okay, staff will now present the staff report and any correspondence on this matter other than those items already included in the record. Michelle, are you over in the corner? Come on up.
Good morning, Judge Burrow Campbell, Commissioner Shannon, and Commissioner Watkins. Thank you today for allowing me to be here for this. As a reminder to anyone in the audience, there is a sign-up sheet for this hearing over there on the table, as well as the staff report was there too. For those that wish to provide testimony at the appropriate time. In the matter of process, to amend the Gilliam County zoning and land development ordinance, any amendment to the text of the Gilliam County zoning and land development ordinance may be initiated by the county court, the county planning commission, or by application of a property owner. In this case, the county court initiated the amendment process by directing staff to proceed. I will provide a quick summary of the staff report as it is entered officially into the record, and the members of the court received a copy in advance of this hearing. The detailed staff report sets out all the applicable approval criteria, along with proposed findings for the proposed text amendments. If there are questions or recommended revisions concerning the proposed text amendments, just let me know. Notice of the text amendments was provided to the Oregon Department of Land Conservation and Development. And notice of the Planning Commission public hearing and county court public hearing was done in accordance with statutory notice requirements. November 28th, the Planning Commission held a public hearing on the matter and is recommending the county court move forward with the formal adoption of text amendments to the Gilliam County zoning and land development ordinance affecting primarily Article 4, Section 4.200 and 4.210. The Planning Commission's recommendation is to adopt text amendments as amended and presented in the staff report that was prepared for the county court. The proposed text amendments to Article 4, Section 4.200 and 4.210 specifically address property setback requirements to the two zones. The two land use zones are applicable only to the area within the City of Condon urban growth boundary. Gilliam County zones UGA-C and UGA-C1. These lands are subject to the Gilliam County Planning Department for land use jurisdiction up until annexed into the City of Condon. The county and the city have an urban growth boundary management agreement outlining these responsibilities. I met with the City of Condon Council at its December 6th meeting. It is important to note the subject lands are within the urban growth boundary of the City of Condon. The council is favorable with the amendments, noting their greatest concern is water and water appropriation. Therefore, the city is requiring all landowners requesting access to city water that are within the urban growth boundary to sign an annexation agreement moving forward. And the council had directed staff at the city to move forward with those arrangements to get that agreement moving forward. But they wanted to make sure that the county is aware that that's a requirement for any development requests that come into the county. Side note there. The proposed text amendments respond to concerns of a lack of available space for a proposed development in the urban growth boundary due to current setback requirements. The proposed amendments would better align with setback requirements for the City of Condon when properties within the Condon urban growth area are annexed in. The proposed amendments comply with the adopted Gilliam County Comprehensive Plan and statewide planning goals as provided in the staff report. The amendment proposed is to reduce property line setbacks for these two zones specifically. More specifically, what was noted in the staff report is under these two zones, article or the subsection E development requirements, the front yard setback shall be a minimum of 15 feet, reducing it from 30. The minimum rear yard setback shall be 5 feet, reduction from 30 feet or 20 feet. And then we reworded one of the bullets that says, notwithstanding anything herein to the contrary, the minimum side or rear setbacks of any property line abutting exclusive farm use zoned lands shall be 25 feet. And then there was a new bullet that was added by the Planning Commission during their public hearing, notwithstanding.
I'm surprised you guys, like, when people are leaving
Hey,
or
Janine.
or doing something.
Janine.
Yes.
Can you mute yourself?
Oh, I'm so sorry.
Go ahead.
Okay, sorry.
Oh, hold on. There you go. Okay, go ahead.
So one of the amendments was an addition that was noted by the Planning Commission, notwithstanding anything herein to the contrary, the minimum side or rear setbacks for any property abutting residential zones shall be 25 feet. And then the 6th bullet under that criteria for development is new buildings and accessory structures shall be clustered within an area not to exceed 1 acre, 43,560 square feet of the lot or parcel. Those are the specific requirements that are specific amendments proposed to the county court for consideration today. It's a very narrow focus of the zone. There are several uses and other criteria in the zone, but today, in the interest of time, and as was directed by county court previously, we were focusing just on setbacks. So I just want to make that clear that even the planning commission was very enthusiastic about reviewing the whole zones, but we kept it to the narrow focus that the county court directed us to. So it's only regarding setbacks today. The process thus far has involved the planning commission making a recommendation with the final decision on the proposed text amendments to be rendered by the county court. The proposed amendments are recommended by the planning commission. The county court can, of course, make its own amendments to the recommendation. Are there any questions of staff at this time?
Any questions for Michelle?
No.
Anything, Leah?
The rear yard setbacks is assuming it's going up to the edge of the urban growth boundary next to farm or whatever, is that
Correct.
the right? Okay.
Yes, yeah, correct. The rear would be at the edge of the urban growth boundary, which I'm gonna fudge a little bit. It's like 600 and some feet from the city limits is how it's measured out.
Okay,
So yeah, the rear would be, which
And
right
then-
now, exclusive farm use abuts everything on the
Okay.
urban growth boundary, correct, for the city of Condon.
thanks. Any other questions for Michelle? Okay, we'll move into the public testimony portion. At this time, we will receive public testimony on this particular issue. Proponents of the application shall speak first. Opponents of the application shall speak second. Neutral testimony shall proceed third, and any agency comments will come next. We'll begin with proponents. Is there anyone who wishes to speak in favor of the application? Should say for those who have joined us on Zoom, if you are dialing in on your phone, it is *6 to unmute yourself. If you are here on your computer, it's the lower left-hand side of your Zoom screen. We'll just pause a minute in case anyone is frantically trying to unmute themselves.
There, I just did receive a text from Leona that says, they're trying to get in on the agenda, link, and they can't, it says that the host has another meeting in progress.
Delaney is working on that as we speak.
Okay.
Is there anybody on our list over there?
Did anybody sign that? Thank you.
Thank you.
Hey, Rod, are you,
Yeah, I doubted before you said it was just.
okay, so you're,
Yeah.
okay, so there's no one on the list. Everyone, I see people put their names and then scratched it off. That's all right. It's confusing. Okay, so I do not see anyone who is unmuting to speak in favor. Is there anyone who wishes to speak in opposition to the application?
My name's Tammy, and
Uh-huh.
I am not on your list, but is there a map that shows the zoning that you're trying to do? On the back of this?
So there is.
Yes, so if you picked up the copy that's on the table, there is a map. And it would be the yellow greenish color. If it's on the outside of the city limits. You have that in your copy, Tammy?
Yes,
Okay.
thank you.
Okay.
Anybody in opposition? Okay, move on to anyone who wishes to provide neutral testimony. And if you're here on your phone, it's *6 to unmute yourself. This is related to the planning issue before the county court. You are here on your computer. It's the lower left-hand side of your screen to unmute yourself. Give you just a second in case anybody is trying to unmute. Okay, is there anyone representing an agency who wishes to provide comment? I do not see, other than the city of Condon on here. Speak now. Okay,
Nobody cares
it
about
does
that.
not appear that we have anybody who wishes to provide comments. So. Sorry, Delaney is texting regarding the other thing. She said if people go to the public notices and announcements page and click the link there, it will work. She is sending and posting a revised agenda as well. So if you can let Leona know that, please, that would be great.
Yeah, Kelly texted me, she got in on that too.
Got it. Okay, great. Does staff have any further testimony?
I do not, thank you.
Okay. Does any member of the county court have further questions of staff?
I do not.
Okay. So we have two options. I am assuming that you guys are ready to close the hearing instead of leaving it open. Is that
Yes.
accurate? Okay. So if there are no further questions, I will now close the public hearing. And then we'll move into discussion. This is 3.1, possible first reading of ordinance number 2023-03, amending the Gilliam County zoning and land development ordinance to reduce property setback requirements in Article 4, Sections 4.200 and 4.210, Condon Urban Growth Area Zones, UGA-C and UGA-C1, and adopting other implementing amendments. So commissioners, if you would like to move forward, there are three motions that are in your packets. The very first one is very specific. So please make sure you actually read those numbers out loud.
I move to approve the amendments to the Gilliam County zoning and land development ordinance as proposed under the land use file number L 2023-L01 based on the findings of fact and conclusions of law contained in the staff report.
Second.
It's been moved and seconded that we approve the amendments to the Gilliam County zoning and land development ordinance as proposed under land use file number L-2023-L01 based on the findings of fact and conclusions of law contained in the staff report. Is there further discussion? All those in favor?
Aye.
All right.
Aye. Any opposed? The motion carried. Now for ordinances, just as a reminder, they have to be read twice. So if you want to proceed with the first reading, then I would need a motion on that.
I move to have the first reading of ordinance number 2023-03 by title only.
Second.
It's been moved and seconded that we have the first reading of ordinance number 2023-03 by title only. Is there further discussion? All those in favor?
Got it on there.
I think that one's the city. Can you guys mute yourselves, please? I'm an aye as well. Is there any opposed? Motion carries. You know what? Michelle, I don't think I have the actual language in front of me. Do you have? Thank you.
For the title.
The title,
Yep,
yeah.
there you go.
In the county court for the county of Gilliam, ordinance number 2023-03, in the matter of an ordinance amending the Gilliam County zoning and land development ordinance to reduce property setback requirements in Article 4, Sections 4.200 and 4.210, Condon Urban Growth Area Zones, UGA-C and UGA-C1, and adopting other implementing amendments. And I need a motion to accept the first reading.
Oh,
You're doing them, so I'm gonna let you keep going.
right,
I had to talk too much on Monday, so.
So I move to have the,
We already did that one.
I move to
Motion number
accept the first reading of the ordinance number 2023-03 by title only.
It's been, oh, go ahead.
Second.
It's been moved and seconded to accept the first reading of ordinance number 2023-03 by title only. Is there further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion carries. Okay, we are gonna move down through the agenda. First up is correspondence and public comment. Individuals wishing to address the county court may do so at this time and at other times throughout the meeting. Speakers are asked to raise your hand to be recognized by the chair, give your name and address, and limit comments to 3 minutes. Before everybody jumps up, here's how we are planning on handling the Board of County Commissioners discussion. If you are here to testify or provide feedback on that, I'd ask you to hold those until we get to that portion of the agenda. When we get to there, we'll have a presentation, basically going over process. And then we'll open it up for conversation with the community. So if you're here to provide comment on that, I just ask you to hold on to that until we get to that portion in the agenda. If there's anything else that somebody wishes to provide public comment on, other than that issue, this would be the time to do it. Anybody have public comment?
Question.
Go ahead.
So in regards to, I think a lot of people may be here, and I am being one of them. It's in regards to your actions on December 6th, which really had nothing to do with your conversations on Board of Commissioners and the structure being set up.
Correct.
So I want to make sure that everybody's aware of the fact that those are 2 different items. And if you want to comment on the decisions made on December 6th, now would be the time to go ahead and do that. If you're going to comment on the structure that they're looking to set up, wait until.
That's correct.
Mine is twofold. I wanted, my statement that I've already prepared is incorporating both of those aspects. So if you'd like me to wait, I will wait, but
Okay.
if you'd like me to go forward, I will go forward.
Okay, I think if it's related to the Board of County Commissioners, that would be fine. If you want to wait until then, you're welcome to read them now if you would like as well. Leave that up to you guys.
Sure, I'll go forward.
Okay, the only thing I would ask is that when you start, just please state your full name and then an address for the record so we can capture that.
My name's Tammy Berkland. I live at 850 West 4th Street. I do ask that you not interrupt until I've finished my statement. I would respectfully request that this issue regarding moving the county court and replacing it with a Board of Commissioners be postponed and adequate time and talking points be given to this community to hear and understand what you're trying to push through. In order to give ample opportunity at differing times to allow for people to hear, discuss, process, and form an opinion and share that opinion on this matter. Constructively, I feel your actions at the very least demonstrate a disrespect and a self-righteous attitude towards this community in which you've elevated yourselves above based on December 6th meeting. I say this not because of a past experience with any of you, only based on those actions, attitudes, and performances that I witnessed on December 6th. I watched that video. I don't need to remind you you're elected. You know that. You're here to serve this community. Please don't lose sight of the definition and the context means to work for, to prepare for, and to place before. This does not mean you're entitled to change the backbone of our community without our consent. It is of my opinion at the moment that you all have misused your authority. The smirks, the sneers, the disregard to citizens that I witnessed on that video, as well as the undertones presented, say a lot about your demeanor to attitude to your authority. I have had a few free moments to investigate this issue, but as I continue to dig, I'm overwhelmed by the community input on a runaway system in which you're doing as you please and not of what this community desires. From high turnover under your administration to disrespect to the people and the employees, to presenting and passing things such as the juvenile and probate issue. I witnessed a room full of people against the motion to move the county juvenile and probate court to circuit court. Only one presented it as a favorable response. Yet in the end, you all three voted to do it. You went against the majority in the room based on circumstantial evidence that was not presented or shared. only other than a statement that you have done your research and an opinion to vote against it. I personally, I want facts. Show me your notes on those conversations. Who did you talk with? What were the outcomes of those conversations? Was it weighted equally across the board? We're never gonna know. You've already done that. You've moved it away from this county. I witnessed multiple people request Judge Farrar and Pat Shannon to recuse from the vote. And not once did any of you address this and offer any justification on why you shouldn't need to. You railroaded yourselves right past that concern and ignored its point to the people of Gilliam County, which I do see as a valid concern. You both cannot be non-biased. Pat, with your sister running, and Judge Farrar, with you taking responsibility of that post. I don't believe that. I, for one, do believe that ethically, this was self-righteous and indignant of an elected official. And I expect better from the people elected in these seats. You're changing the backbone of locality for this community. That's not a decision for me. It's a decision for we. This again is a decision that is not one that can be put back after your term. Please bring this to a vote to the citizens. And please have informational sessions at varied times so people have the ability to hear, discuss, and process what you're proposing. And I thank you for your time and your consideration.
Dana.
I would like to speak on that issue also, if I may.
Yep, just make sure you state your name and address for the record first.
My name is Dana Hahn, 521 North Lincoln, Condon. And I want to thank you very much for your presentation. And I want to tell you that I was the one that said that it struck me as being self-serving, underhanded, deceitful, and manipulative. You have done nothing to change my mind. I also said to you that I was told that you, Liz, have stated that you do not answer to the public, that if there was something you wanted done, you would do it regardless of the fact the public would be against it. I asked you if that was a true statement, and you said no. And I will remind you from the newspaper, it says a majority of those in attendance were not in favor of the changes, but Leah Watkins made the motion to approve, Commissioner Shannon seconded, and the motion passed unanimously. You did precisely what you told me you didn't do. You ignored the public comment. Thank you.
Thanks. Anybody else? Steve?
Do you mind if I step up?
I think it might be, especially if you guys are offering comments in the back so that the owl can pick you up. But I think folks in the front row, it'll probably pick you up just fine. So come on up, Steve.
With all due respect, it was a lot to talk about. There was some comments made about me at the last meeting. With all due respect, I'm requesting 2 additional minutes. Would that be possible? Okay.
Go ahead.
Thank you. My name is Steve Schaefer. I live at 211 West Penoyer in Condon, Oregon. I'm the former Gilliam County judge prior to your term, Liz. So I will begin my testimony. Judge Farrar Campbell, Commissioners Watkins and Shannon, thank you for having me. I'm here to ask you to slow down on your movement to change Gilliam County's structure of government. This structure of government has been in place for over 100 years, and to tear it down in a 6-week period of time is mind-boggling to me. The speed at which you eliminated the judicial duties of the judge position was disheartening, but more so suspicious. There's been 2 meetings regarding this action, one in May of 2019 and the last meeting on December 6th. Although on May 16th, this meeting was full of proponents, most of the testimony that happened there had an opposing view. It was a show of hands that determined it best to send juvenile justice to circuit court on a trial basis. Judge Farrar Campbell, you said during your campaign you wanted to eliminate the judges' judicial duties and look into changing how the county government was structured. 5 months into your position, you have a hearing, which most in attendance were in favor by show of hands to moved to circuit court on a trial basis. The subject matter during that meeting was, and can this be done? Can circuit court do our juvenile cases? We found out, yes, they can. What was not part of the discussion was how removing the judicial duties would force a change in the county's governing structure. As far as I can tell, in the 4.5 years to follow, this subject hasn't been brought up as a discussion or action item on any agenda until 2 weeks ago. Why hadn't this come up before December 6th? Commissioner Shannon, you said you contacted different leaders and experts. All those experts, all those leaders I knew. A couple I was shocked to hear they were considering giving it up. Follow-up contacting indicated, no, they're not considering giving it up. Their move to circuit court is not that good. Another judge you mentioned, it was after being elected that this person announced he wouldn't do judicial duties. 2 years later, the end of my term, they were still trying to clean up the mess. You stated the main reason Morrow County eliminated the judge was children drowning in a bathtub. I had received calls from the court members 6 months prior to them making that decision. And that reason was never mentioned. In your couple of weeks of research with the experts, not one effort was made to contact any of the people in our neighboring counties or our county who have performed those judicial duties. Nope, you didn't contact anyone who had been in the trenches, not a former DA, former juvenile director, or judge. Why? Because they may oppose your thinking. It's obvious to me you didn't do enough research. Commissioner Watkins, your reasoning was extremely shocking to me. I thought I remembered every hearing I oversaw, and this one I had no recollection of. Protecting the youth involved in dependency cases was something I took very seriously, and this information was extremely upsetting to me and my wife. I racked my brain trying to remember the child and the circumstances. I knew of the family, the results of grand jury, and the trial that followed. But I couldn't remember the shelter and jurisdiction hearings that placed the child in that guardianship. I wanted to see the court case file, but I knew there was no way I had the authority to see it. Both my wife and I were a mess. I'm thankful somebody did investigate the guardianship. This was a case from Wasco County. The shelter, jurisdiction, disposition, and review hearings were all held in Wasco County under a circuit court judge. That is a fact that those two experts that Commissioner Shannon used, or two of the experts that Commissioner Shannon used, had that information and chose not to pass it on. It was insinuated there were other cases that have created current concerns for the court. I hope you will reach out to me and see if it was a case of mine before you use it as justification for your decisions. During the meeting, the three of you treated this like it was the Holy Grail. I agree with the county's paper of record owners and editors' opinion. It changed the tone of the meeting. This was a major decision this court made on December 6th with what I and many others was done in a wham, bam, boom way. A decision made with the lack of and wrong information. I changed my mind. I'm not asking you to slow down. I'm asking you to halt any further movement until you get better informed and the people get full understanding of your intentions. When you heard this was something the voters, a comment was made, when you heard that this was something that voters should decide, the response was, why shouldn't we do what the rest of the state is doing? We can't be spending every decision making out to uninformed voters simply because somebody doesn't like the decision we make. This was a major decision. I believe there are voters in this county as well informed as you. And they disagree with you and should have their voices heard. Not in a phone call to you, but in a public setting where those you claim are not informed can get informed. To contradict your everybody is doing it this way, there was one statement I heard 1,000 times while serving as county judge. If you've seen one county, you've seen one county. The meaning behind this is every county does things differently. It's based on constituents' preferences. It was stated during the court meeting, we are unique. And so are the 35 other counties in the state. I've changed my mind again. I'm requesting that you table agenda item 7.2, begin the steps to rescind order number 2023-1 before any movement goes forward. Thank you.
And Pat, go ahead.
Yeah, I reserve the right to rebut some of the comments that former Judge Schaefer just made. And I want it to be clear that when I did my research, I did not reach out to those that had previously been handling juvenile cases because they had not been involved in moving those cases to circuit court. I talked to the 6 counties that I said I talked to that have moved those to circuit court in one way or another in an effort to find out if they thought that was a bad mistake. I did not receive any communications that they thought that was a mistake in error and that they need to pull it back. And the comments I made about what's going on in the rest of the counties were based around, there isn't anybody in the state presently in their county government hearing those cases, and I stand by that. Yeah, I think I'll leave it there that I did do the research where I thought it needed to be done. I don't think that it was going to do any good for me to hear from 2 past judges who you had recommended that had lost their elections. So I did the research where I thought it needed to be done.
I would like to also comment because Steve called me and I did not name his name in the court meeting, just to be fair. And I did apologize to him for
Yes,
saying that because that was a misunderstanding on my part. I thought that, and I did apologize to you.
An
So
apology accepted. I should have relayed that information in my testimony, but we did have the conversation. I did reach out to both of you, full disclosure.
Yeah.
That I called both of you and we had the discussion on both of those subjects that we had.
And I also reached back to you to
Yeah.
make
Thank
sure you
you.
understood me clearly.
Absolutely. I still completely disagree with you.
And we agreed to
that's
disagree.
okay.
And we agreed to disagree and said that's okay.
You know, you got your point.
Dana, before you, I think Kara had started to raise her hand, so I want to double. Well, since you've already spoken, I'm going to go with Kara.
Oh, wonderful.
I just want to be very clear. I wasn't here for that last hearing. I was at a conference that I was speaking at. And you did a great job with your testimony. I was getting a little nervous, but I would please ask everyone to remember that children who've been traumatized re-experience that trauma every day. And it horrifies me that there's a public record that is up on our county website for everybody's review that has enough specificity about a recent case that child can be identified. I heard about it when I was still down in Tucson. I knew the case. I'm the one that first took the call in Wasco County because yes, Wasco County fumbled this one hard. And that's where the child was located. And I still do the sex crimes. I'm Kara Davis. I'm the district attorney, if you don't know. I still do sex crime prosecutions for them. The word of what was said in here gets around. And I don't want anybody, whatever their point may be, trying to score political points off the back of a traumatized child. So please, if you're going to specify a specific case or talk about a specific case, please be vague, because that conversation, and I know heat of the moment, things come up, it happens, but please be cognizant that this is a recorded public meeting that's gonna exist basically in perpetuity. But number 2, all of this conversation that I'm hearing, I would like to request of the county court a copy of the agreement you have with county council, because anything that isn't covered by that agreement is going to be my problem if it pops up. So I would like to know where the parameters of where I might be asked to step in if people get litigious. Please, pretty please, I would really like a copy. Thank you.
hold on, Chris?
Good morning.
Hi.
I'm speaking, sorry, no, I'm speaking as a candidate for the position of Justice, Gilliam County Judge. So I'm gonna read what I have written here. The Gilliam County Court, effective December 13th, transferred juvenile and probate jurisdiction to the Gilliam County Circuit Court. I'm addressing you regarding probate jurisdiction. At the December 6, 2023 court meeting, there was no discussion about the benefits or drawbacks of relinquishing probate jurisdiction to the Gilliam County Circuit Court. Probate simply was included with the larger juvenile jurisdiction matter. ORS 111-055, 075, and 115 grant exclusive probate jurisdiction to 6 Oregon counties: Gilliam, Sherman, Wheeler, Grant, Malheur, and Harney. ORS 111-115 allows case-to-case transfer of estate proceedings, but not full jurisdictional transfer in these 6 mentioned counties. I need to disclaim what I'm saying. I'm not a trained lawyer. I am a candidate trying to advocate for my own candidacy, so I need to clarify that. I spoke with an attorney who specializes in probate law from Malheur County, one of the above named counties. He stated this very scenario happened in Malheur County a time or two over time. They have a county judge, as does Gilliam, Sherman, Wheeler, Harney, and Grant, because of this probate law. It is not lawful for the Gilliam County Court to transfer probate jurisdiction. Judicial function cannot be removed from the Gilliam County judge position because of this probate jurisdiction that is permanent unless you have a legislative act. ORS 203-320 states that the county court in which the county judge has no judicial function may order the office of county judge abolished. Probate jurisdiction provides this jurisdiction function, therefore your county judge position cannot be abolished the way I read the law. Thank you.
I have one other thought in rebuttal to Judge Schaefer's comment. In what happened in Morrow County and what I had stated in Morrow County was information I'd received from past Commissioner Don Russell. And what he said, and what he told me, and what I said, was that when they started down the road to removing juvenile, that was one of the issues that had started down that road. I did not name names of it. I simply named what he told me about the process that Morrow County went through as they started to remove the judiciary responsibilities from the county court at that time.
Okay, if you're going to, I would say, my very first meeting, very first discussion with it was with Don Russell and Gary Neal at a Regional Solutions Business Oregon combined meeting at Hamley's in Pendleton. Very first time that information was brought over to me that was what they were looking to do. I met with Don Russell probably 2 or 3 more times after that, again, discussing their thoughts of changing their structure of government. I met with Terry Tallman probably 10 times and having the discussion with it. The other commissioner at that time was Leanne Ray. I met with her twice. One of the times was in Condon. Actually, we held the district AOC meeting in Condon at that time. Those were the times that I had the conversations with those people, and the whole conversation did never mention that as being an issue.
I'm just telling you about my
You know,
conversation.
your statement was that it was the main issue, and I would think if that was a main issue, it would have been something brought up by one of those 3 during those many times that we talked.
I would say it was,
Sorry, I wanted to say this prior to even doing my testimony. As all of us here, I have many different voices that I utilize, and I have my grandpa voice, I have my working voice, and I have my coaching voice. And my intention was the entire time to use my grandpa voice. I know I'm not doing that, and I apologize for that.
well, I feel a little bit targeted as you're trying to discredit the 3 members of the county court in a way to discredit them, and that I didn't do my research. And I believe I did the research I need to
I'm
do.
not saying you didn't do research, I'm saying it wasn't complete.
I can actually concur that when I came into office, I did talk to former Commissioner Russell about what led to them, and he did mention specifically the incident that Pat is describing. So I totally understand, but I also know that I personally had a conversation with Don Russell in 2019 that indicated and exactly what Pat said. So I am not surprised that he may have shared that as well with you, Pat. Dana, I'm gonna go to people who have not
That's okay. I
spoken
just have
yet.
a question, because I'm a little bit confused about what we're addressing here, because my comments were directed toward December 6th. But if we're talking about, the county government change, I have additional comments.
We, as I indicated before, if your comments are around the Board of County Commissioners discussion, we will get to that later in the agenda. So the public comments right now can encapsulate the December 6th
Thank you.
decision and anything else. So you just
Because I
right
see
there in the
that
back.
going back and forth.
Yeah, I think some people are
Yeah.
blurring it in their testimony, which is fine.
Hi, we've never actually officially met. I'm Eric Aiken. I'm the Tri-County Veterans Affairs Officer.
Hello.
And so, nice to meet you, commissioners
meet you.
and judge.
Welcome.
Mine isn't a testimony. I actually have questions.
Okay.
And it has to do both with the probate to help settle everybody and also with the board decision. For the probate, did you guys seek legal counsel outside the county, legal counsel, to see what other county jurisdictions did to make sure the probate law was no longer an issue?
So we rely on legal counsel that is an outside firm, a municipal firm that is based out of Eugene. They thoroughly reviewed these questions, and the court's decision was based on the advice that they provided to us.
Because as it looks to the county, being also a county resident at 25 Hemlock, it looks illegal in that sense, as Chris pointed out. And so I was wondering if you seeked other legal counsel outside of what the county has on retainer.
So I would say that attorneys, and maybe Kara could confirm this, attorneys are not going to provide advice if they are not actually hired by us to do that.
Except
So
for me.
except for
And
potentially
I'm authorized by statute to provide legal counsel to the county court. I think it's 8.690 or something like that. That's why I'm getting nervous about what your county council like retainer agreement looks like.
yeah. So to your answer, of course, with something of that magnitude, that would have been thoroughly reviewed by our legal counsel.
Okay. And then the second question is, have you considered the negative impact that moving to a board of commissioners would have on all the services? Take veteran services, which is the one I know specifically, with the IGAs that are currently in place and the financial impact it would have on that service alone under Measure 96.
So I just want to clarify that if you have read your packet, if you've looked at what's online, there is not a court order before the court today regarding the Board of County Commissioners. For those who have requested that we have public discussions, this is one of the first public discussions regarding that. So there is nothing, as you'll see in the briefing, so those very questions you raised, I think this session is meant to elevate those as things that then
Yes.
county court staff can take back and bring back to the commissioners to provide at upcoming meetings. So I appreciate you raising that. Those are things that I think there'll probably be a list that Miranda will compile based on people saying, what about, this and that, that then we will need to go back and provide information regarding.
So you should explain to her what you explained to me last night about what you think might be problematic about the intergovernmental agreement if the structure changes.
So the IGA, as it sits now, it falls under your position directly. With that being said, how the state law reads is any changes to the funds, because right now Gilliam County
produces 4,200 to my service directly. Any changes to that void my funds from the state under Measure 96. So therefore, I have to reapply. That grant window is now closed. There is no reapplying until the next fiscal year for the state. And that starts May and doesn't close until, I believe theirs starts October 1st, 2024. And so having this come at this time after every fiscal year, state, federal, and all windows have closed is poor timing in my decision or
Your
my opinion.
department?
For sure.
Actually in all departments, because it falls across the board when you're talking state.
Sarah, could you mute yourself, please?
And state and federal funds, which help. And so having at least the IGAs looked at, and I don't know how many there are for Gilliam County specifically,
We have a lot.
A bunch.
every county does. That's- and so having them looked at prior to making this decision and talking with those departments, so they're on board and being transparent also with the public, because right now I heard, I wasn't at the December 6th meeting, as I was at a different meeting. It was that this was going to be pushed through as fast as possible, moved to commissioners before the next election, which happens in May.
The only thing, and I know this came up last night because at the meeting and I have questions around how the IGs work. I do know and would state that I think this happens often, and once a governing body signs an IGA, whether that changes or not, that's the IGA that's in place until that it's re-signed. So I don't know legally how that is, but that seems to be what's happened in my 3-year tenure as a commissioner. We often get IGAs that have been, that are in play, are working, but have been signed by a previous commissioner, or, so I don't know the answer to that.
So
But your point is well taken.
yeah, I can tell you, being at Hood River when similar actions were being taken.
Yeah.
And being the direct hit of that.
No, I think
settler in this position in 2017 is it does take a negative impact, and it could just shut it down completely.
I absolutely
I don't know
understand
about
the
other
concern.
ones. Some IGAs do have the ability to roll over, but Measure 96 is very specific when it comes to veterans.
Thank you for raising that. Other public comments at this point?
I just want to apologize to the court for that. My vote is no.
Not a problem. I do want to address just briefly the question that Tammy had about conflicts of interest.
Yes.
Just so
Please.
that folks are very clear about what constitutes a conflict of interest. Those who are current public officials probably know that. I'm sure Steve knows that as well. That a conflict is only present if there is a financial implication for the voting member. So because that particular decision had no financial impact on me and no financial impact on Commissioner Shannon, it is not a conflict of interest under state ethics law. So we routinely ask for advisory opinions from the Ethics Commission. And they have confirmed that it is not a conflict.
And I'd also like to add, because the word biased was used in that conversation. And when you use that word, my first thought was, and I wished I responded, is biased one way or the other. And I am absolutely biased one way or the other to everybody I've ever met in my life, based on the experience that I have with them. My job is to not let that bias interfere with what the correct decision should be made that I'm responsible to make. We all have bias about everything.
That that's the way it's supposed to be.
Mhm.
I don't think that that's the way it is.
What was that?
I understand that that's the way it's supposed to be.
Well, it is. We just, we have bias about our experience with anything and everything. That's what a bias is.
Okay, I'm gonna go to Denny. Did you have something too, Sky? Okay, so we'll go to Denny first and then we'll go to Sky in the back.
Just a quick question. Does the financial conflict of interest and declaration thereof apply only to the elected official and not to immediate family member?
And their immediate family.
It does apply to immediate family members as well.
Would have you
Under the-
reconsider whether there was such?
There, and that particular decision, there was no financial implication. Nothing has changed with salaries or anything related to that. So there is no financial implication. Sky.
Want to sit down.
Make yourself at home.
Sky Krebs, 73654 Highway 74. I own Opera 7. Thanks to the county court for allowing me to speak. It's been brought up twice before from Judge Schaefer and from Chris about the ORS 111055 and ORS 111075, which to me read pretty black that the county, Gilliam County, is supposed to have a county judge. Now, if you saw legal counsel and got a ruling on that, I'd be interested to see that, because to me, it is an unlawful act to try and do away with the judge, according to those two ordinances, those two ORS statutes. So I have a real problem with how you're going to get around those two statutes. If there's a way, state it. So I would say at a minimum at this meeting, you ought to have a motion to reconsider until we can get clarification on how those two statutes do not apply in this case, because to me, these apply specifically to Gilliam County, as been previously mentioned. Thank you for your time.
Chris.
Okay, now I'm putting on my justice of the peace hat, okay? Because I currently handle juvenile violations as the justice of the peace. So last night at the meeting that Kara Davis had, the issue of the violations came up, because I'm wondering if I have jurisdiction over those violations. If juvenile jurisdiction was fully transferred to Gilliam County Circuit Court, we had an agreement with Gilliam County Juvenile Department to transfer those traffic cases, game, fish and game, boating, some of those juvenile violation cases. So I reached out to the Morrow County Justice of the Peace today. I thought that would be a good place for me to go to find out how their process worked when Morrow County transferred that jurisdiction. And he says, and I'm gonna have to work this out with Kara because I think she disagrees with me, that there is no jurisdiction for the Justice of the Peace to take those cases until there's an agreement that Circuit Court, what Circuit Court did in Morrow County is they had to request of the Justice of the Peace to take those cases. So Kara, I have a court order from Morrow County. We need to talk about this. I just feel it's a jurisdictional issue because ORS 419C.005 establishes jurisdiction over violations of law and for juvenile cases. And it doesn't specify between criminal and violation. I'm not saying there couldn't be an order, but at this point in time, unless I hear otherwise from our DA, those have to go to circuit court. That's the MIPs. He also told me about a 12-year-old that got a driving offense that he had to deal with because of this. So, yeah.
I will say, Chris, this, you had asked that question on December 6th. If you remember, the juvenile director out of Wasco County attended that meeting. She had indicated that it appears maybe that Circuit Court does have a similar agreement with Wasco County. And after you asked that question, I reached out to Brian Beach. I don't know if he's connected with you too. April was on the call as well. But I thought where they left it was that the three of you guys were gonna work out those jurisdictional issues directly with Circuit Court.
Yeah, he asked me if I'm gonna take the violations, and I haven't decided at this point if I was or not, so.
Okay.
Thank you.
I've already discussed it with the person I think that's most likely to get appointed your position. I don't think it'll be a problem.
Got it.
Comments? I think this is another addition to the.
No.
Hi, Mike. How are you, Mike? Another addition to the lack of, I mean, this is happening after the fact of this this decision being made.
It has to happen after the fact, though. The circuit court cannot make that agreement until the jurisdiction is moved.
Gathering.
Let me go.
Oh. Okay. Any other public comment at this point that is not related to Board of County Commissioners? Rod?
Rod McGuire, 66325 Upper Rock Creek Road. I'm riding a whole different train, so I feel out of whack here. I also got a bad eye and I wrote some stuff down. I'm here to talk about a Woolery update and where we are and where we're headed. And many things were brought up last night about transparency, fairness, personalities, and small community. So my thinking was county court was there to help and to listen to projects. The Woolery has had many roadblocks, but we keep moving forward with the same board of almost 10 years. The grant board, the grant program seems to me to be somewhat discriminatory. A couple of years ago, we applied for a technical assistance grant and we were the only ones under the applicants denied. The grant was for $10,000. When asked why we were denied, it was said that it was Rod McGuire was rumored as retaining funds for his own gain. This really upset my board. Do you think they would stay with me for my own gain? This is a hell of a thing to say of a county government. There's no one more passionate about this project than Rod McGuire, and there's no bigger donor. The Woolery board all donate not only funds, but an amazing amount of their time. So we had a special meeting with the county court. My secretary treasurer went with me, Joey's Corley right here. He was more upset than I was. When they accused me of stealing, that means Julius was also involved in stealing. He wrote a very concerning letter. So after 3.5 hours meeting with the court, they agreed to give us the grant, but said, don't ever come back again. We thought this was supposed to be a fair and unbiased decision. So the Woolery has kept moving forward on its own, paying for accounting, legal services, engineering, and so on, spending tens of thousands of dollars. We recently, in the last couple of years, accomplished a lot. We got a zone change, road easement done, the site plan done, water to the property. We have beautiful letters of support from the Port of Arlington, the schools, and the support of the city of Arlington. We do way more than want a building. It's called A Place Together. We helped the junior senior class raise funds for their banquet and prom. They had zero money. When COVID came, they had no way to raise money. So the Woolery stepped up and partnered with them and doing a power breakfast, and it was very well received and supported by the community and the green energy workers, raising a little less than $1,800 each. Then we always use a group of high schoolers for Oktoberfest, paying the kids for the cause of $100 per kid for having fun. The Woolery also produced a play and a dinner with April Amont, with our youth that got a drama club started, raising funds again. Where we are currently, we are in the final phase of the engineering. With the price tag of $35,000, the engineer said the county court would probably help with this. And we said back to him, it was never to come back again. So we make payments. After each fundraiser, we send a check. We have invested tens of thousands of dollars and countless hours of donated time only to be ignored. And now we have Greg Smith on our team, and he has inspired us to keep on. He has viewed our site and loves our project. That's all I have. Thank you.
Further,
So I have a couple questions for Rod.
go ahead.
What grant was it that you applied for?
It was one of the little grants, the $10,000 grant.
Oh,
to
so
help us pay
special
for these
project,
kind of things.
special project?
Yes, that must be what.
I think it was
I call a
special
technical
projects.
assistant.
20. Leslie, were you on the court then?
The,
I know the county court gave a lot of times, but I can't remember the spot.
I would say, Rod, that how I recall, now this was years ago, if I recall, like maybe the first year you were on the court.
yeah, maybe, and I
possibly, or
remember,
Leslie's last year, one of you, so we're talking like
Just a couple of years.
3, 4 years ago now, so I'm trying to go off the top of my head. If I recall, I think the direction from the court was that in particular, it was a request maybe for an event that we had said, but I'd have to go back and check the record. I would say that the special projects grant is still, for the north, you would be obviously in the north end for those, is still accepting applications, so.
We were told never to come back again, so we never.
Rod, my recollection is that the court at that time, if I'm remembering right, which this would have been when I was very new on the court, was that they asked to see some progress, which you just explained some progress. There's never been another presentation on where you're at with the project. Before there was any more money, there was never any statement made telling you not to ever come back again. It was simply that we wanted to see some progress because we didn't know where we were at in the process. Knew it had been going on for a long time and what visually is going on that we could weigh in on and that you could let us know about. And we haven't had any updates.
So if the special projects grants will open again in the spring, and so that would be an opportunity. The capital investment grant has changed, and I don't think it could pick up, if you've already raised 75% of the project cost, it could pick up the other 25%, but your best bet for that amount that you were talking about would be a special projects grant. And those capital investment or those capital projects are up to $30,000. So you would just need to submit an application with those updates. So it sounds like maybe there was a miscommunication, and I'm glad that it came so that we could sort out where the court is on that.
I don't think,
And,
I mean, if any court I was on, I'm not gonna tell you not to come back.
I think the special projects now is actually, the limit is higher than it was.
Than it was before. It is.
It's 20 now. What is
It is 30 for capital related projects, 7,500 for events, and 20,000 for innovation projects.
And there seems to be more money in that pool for those grants.
Especially on the north end.
It is underutilized in the north end.
Yeah, it used to be
North end.
that it was pretty tight on both ends on how much money there was in there, but I think there is quite a
And
bit.
it carries over,
It does. It rolls over.
rolls over.
It used to be really tight.
Yeah, it was only, there was maybe $100 and some $1,000 worth of requests for a $50,000 pot at times. Yeah,
Yeah, and it's been
So-
absolutely the opposite. So I've been on the court
Yeah.
and nobody's ever asked for all the money.
so
that's
I
been-
would encourage you to come back.
Okay.
So,
Appreciate that. We had a grant writer helping us and then she died. And so kind of left us in limbo.
well, our agreement, the person, the Kelly consultant.
Well, which is, and
They be a
Judge, you
candidate?
talked to me about the program that we're offering for grant writing and other assistance.
Okay.
And that, you know,
That would have helped them.
Yeah.
Okay,
Sorry to disrupt the other.
no, actually, that was helpful. Okay.
Good to have a break.
Right, fine.
So we are an hour in. We have moved, I think, through public comment. Anything else? Not Board of County Commissioners, but that'll come later.
This is
Okay.
Michael Weimer at the City Hall in Condon,
Hey, Mike.
and I want to let you know that there's so much echo in the sound that it's almost impossible for me to understand what's being said at the meeting. And I have this problem at the county court in Condon where there's just not enough volume coming from the microphones at the county court to be able to hear what's being done. And I brought this to the attention of Delaney Watkins, and she said she was going to research it. But this is a matter of ADA. And I
So
appreciate
Mike,
you hearing that.
Is it the audience comments that you're having trouble hearing or the actual county court?
I'm not hearing you good because of the echo.
The county court.
So is it the county court or is it the audience member comments?
Oh, it's the court members, especially Commissioner Shannon. And also, well, I'm here, he's been pretty good today, but in the county courtroom, it's all, the only one I really hear good is Elizabeth. And the rest of the people that talk in those meetings is a blank.
You
So
can thank Cindy Osterland in 4-H for that, Mike.
I didn't understand that.
Well,
I have a real problem. I can hear lots of noise, but it's not comprehensible.
So I will say, I'm speaking extra loud, hoping this is clear, Mike, that one of the things we are seeing, we believe that Zoom will actually allow for closed captioning. And so we're figuring out if we need to turn on something, you may need to turn something on your end to actually have the closed captioning coming up so that it's capturing and transcribing in real time as we're speaking. So
that would be on Zoom or a video meeting, which, watching the video afterwards, but to actually be present in the same room is next to impossible. So I appreciate having the opportunity to bring this up to people's attention. And I know I'm not the only one that's not hearing good at the meetings. Thank you.
I know from watching some county, Board of Commissioners, county courts, whatever, that a lot of them make the people that are gonna talk get up to a microphone and talk into the microphone. So
that may be something that we can explore. And the circuit court is, it's wired actually by the circuit court. So it's a little bit more complicated for us.
Maybe it would be easier for him to hear, people would step up to the chair. Rather than speak from back here.
Agreed. I think I said at the beginning, if folks are in the back can come up so the Zoom mic can catch you. Julius.
I would agree with what he just said. I wear hearing aids and I have a problem with Pat. And I would suggest there's some kind of a sound person. When I first came in here, the chairs were pushed halfway back to that wall for some reason. And I knew people over there couldn't hear because I can't hear. I don't go to the city council meetings anymore because I can't hear. I whined and sniggled for years for them to have some kind of a sound system. But it costs too much or something, I don't know, but, there's a lot of older people that put up a lot of effort to come to these meetings and you can't hear. I can't hear these people back there half the time. If there was somebody walking around with a mic and so we could hear what the heck's going on, it would really make it a lot more interesting. And I listen to your Zoom meetings. And the same thing that he just mentioned.
So one thing on the Zoom meetings, Delaney did text, she is.
I just tried to turn it on, so I'm not sure if it's working. It is on my screen, but it's not showing up there.
Yeah, so.
I can't hear what she said.
She's talking to me. Okay, so Delaney did confirm that if you are on the Zoom and you just, so you know, and you need some help being able to understand what's being said, there is a closed captioning option. You have to turn it on your end. So when you're on your computer, you have to be able to find that button. But it is transcribing us actually in real time as we're speaking right now. So for those who are not familiar with the Zoom platform, if someone could use that assistance, we're enabling it on our end so that it can transcribe. So folks just need to click that on their computer when they're actually listening from home.
Circuit Court has hearing assistance devices that are hooked up to the court sound system, so it amplifies everything that's being said in circuit court. So you could probably ask Ryan at least about borrowing those assistance devices when you're at the Condon location, because it's tied into the wiring.
Thank you for that. Yeah, that's great. Okay. Does everybody feel like we've got enough on the public comments, ready to move into the actual agenda?
Public comment, just over this. If we have special project money, why aren't we spending special project money on sound devices? The citizens should be able to be involved. And if they're bringing forward the fact that they can't hear, you guys need to help them with that. That's an ADA issue. That's something that you guys do need to do, not just leave it on the onus of the person to look for a closed caption button. You're talking about elderly people who have no technology experience. And to ask them to find that is not, that's not correct. That's not ethical. That's not even right, right? That's like asking my grandmother, Grandma, can you please, get on TikTok and make a video? They're not gonna do that. You guys have to help.
I think there's been several solutions raised that have been,
So we're gonna make a motion to make that happen?
we actually don't need to make a motion to make that happen.
We can
I
make
can
that
do
happen.
that.
Perfect. So
Do you have
next
a
meeting, you guys-
suggestion?
Yes, let's make it. Let's buy the equipment.
Other than complaints about my voice and lack of volume for the last 3 years, I hadn't really heard how big this issue is until the last week.
Perfect.
We actually just got a complaint about it this week, so we will address that.
Long-going complaint about me, but not about this.
But we can't help that he mumbles, so I can't do anything about it. Okay,
Push the microphone over.
we are moving on. Let's move into consent agenda. Again, commissioners, this was a revised one, so the minutes are off of there. Do you have any questions about what remains?
I do not. You?
No.
I
But
move to
I
approve.
would like to comment though. If, on the, consideration of Daleen. So 5.4, and I just want to make a comment that, this is a good move because Daleen has actually been acting as the administrator for the public health at South Gilliam Health Center since Holly left at the end of April. So this is basically just making that an official stuff, but she has done a stellar job. I'm excited that we are moving forward with putting her in there. So she has a resume ready that will be attached to the letter that we're going to approve. And so that'll get sent off to OHA and then she'll be officially, as of January 1st, our public health administrator. And then the last thing I would like to say, since this is Delaney's last official meeting, that I just want to thank her because I don't know if I could have taken on the public health at first, if I hadn't had her to give me documents and guide me through what was going on. So thank you, Delaney. So anyway, you can move.
I move to approve the consent agenda.
I second.
So moved and seconded to approve the consent agenda, which consists of consider appointment of Daleen Wilson as Public Health Administrator effective January 1, 2024. Consider approval of amendment number 5 to IGA number 18008 with Oregon Health Authority. Consider approval of agreement with Transportation Safety Office for Speed Enforcement Grant. And consider approval of intergovernmental agreement for services with Oregon Department of Emergency Management for search and rescue air fuel. Is there further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries. Okay. Moving right along.
I'm sorry, how much was the speed enforcement grant? No, if you don't know off the top of your head, that's fine. I was just.
I got a copy of it.
It's here.
I think it's well, I don't see fits on her, but if I recall,
Is it right after the public health?
I wonder, I think it may be a reimbursement of actual overtime costs.
Yeah, I mean, that's how, or sometimes they have the grants first and then we do the overtime and then get paid out of it.
I'm trying to see if there's
I
a,
say we, like I do all the work. To do none of it.
I don't know if they have a cap in here.
Is it this one right here?
No, it's the last one.
That's scary.
Yeah, it actually doesn't look like they have an amount in here, Kara.
Okay,
Oh, wait, no. No, so that's a Gary question.
okay, thank you.
Okay, let's move into 6.1. Consider approval of early release of fiscal year 2024-2025 small business grant program funding. So commissioners, as you will recall, during our December 6th meeting, the Frontier Chamber of Commerce came here. Brooklyn is in the second row back there. Gave us a quarterly report and let us know that nearly all of the funding that we committed for 2023-2024 small business grant funding has been committed. And so they have needed to put a pause on considering new applications until there's additional funds available. The consensus of the court was to go ahead and release early the upcoming fiscal year funds so that they can restart the program in the new year and begin taking applications again. For those who are unfamiliar, the county court provides funding to the Chamber of Commerce to administer a small business grant program. People submit applications directly to the Chamber of Commerce. They have a number of criteria. They have a grant review internal to the chamber. It's not something the county court weighs in on and who gets grant funding or not, but the chamber has generously offered to administer that on behalf of the county. So they are out of funds, and so the question today is whether to provide additional funds to them. So basically, Commissioner, since there was already consensus, what I just need is an actual formal motion on the record so that Delaney can get checks going out to the chamber.
I'm moved to approve releasing the fiscal year 2024-2025 payment to the Oregon Frontier Chamber of Commerce for the Gilliam County Small Grant Program in the amount of $82,500. With $75,000 for grant funds and $87.50 for the administration fees on December 20th, 2023, and authorize the county judge to prepare and execute the letter of agreement reflecting the same.
And I just wanted to confirm those amounts. Total amount is $82.50.
$82,500.
$75,000 for grant funds and $7,500.
$7,500 for administrative.
Okay. Just wanted to make sure that was on the record. Is there a second?
Second.
It's been moved and seconded that we approve the fiscal year 2024-2025 payment to the Oregon Frontier Chamber of Commerce for the Gilliam County Small Business Grant Program in the amount of $82,500 with $75,000 for grant funds and $7,500 for administrative fees on December 20th, 2023, and to authorize the county judge to prepare and execute a letter of agreement reflecting the same. So further discussion, all those in favor?
In further discussion, I just wanted to say that as we discussed in the last meeting, if the public didn't know, this program seems to be using more consistently than what we authorized. And so we keep moving the date back further and further to keep it funded. And I've asked to kind of keep that in motion so we can have conversations with the chamber on how the program's going, and they can come back at any time in 24-25 for another request when those funds begin to run out, because we do want to keep money available for our small businesses in Gilliam County. Thanks.
Got it. Okay, so we'll call for the vote. All those in favor?
Aye.
Aye. Any opposed? Motion carries. Okay, we're moving on to 6.2. This is a discussion regarding the outdoor library electric vehicle parking project modifications. Pat, did you want to?
Yeah, to pass information, a little information on. I was in City Hall in Condon the other day, and council member up there, Donald Jameson, came in and communicated with me, he did not think it was important to have a green space behind the library,
Okay,
which is, the project was set up to do EV parking, EV charging, and a little green space between the charging units, and we've been out to some design, haven't got very far on the green space part, but we received $817,000 blah, blah, blah dollars from the, through a DOT grant that Miranda and I worked on to install the, EV charging units under the direction administration of DOT. And so that's kind of in the works and going, and we've been meeting with DOT on the process to move that part forward, but the city, and we have not, I was informed to apply for, or set this up for them through any kind of city planning, which has to happen.
mhm,
And I feel some resistance on getting much, I don't know,
on the green space.
on the green space part of this, that we're really gonna get a lot of, support for that. It was pointed out to me, we have green spaces all over Condon, don't need anymore, pour a cement slab. But have a place so Paradise Rose can come park their unit and do a cook and, you know, those kind of things. So I think there's not support for the green space, but there was, however, in that conversation, a real need for at least one good fast charger in Condon, Oregon.
Mhm.
And so what I would like to suggest that we start the process and get, numbers put together and costs put together for the county to provide one to get us through, bridge the gap until this is in on the larger scale EV charging, which will be a year and a half before it's actually in
So,
place and ready to use.
so one thing I think that we need to double check with the state is the letter that they sent us said if you begin the project, you lose the grant funding. So we
This
need,
would be a separate project.
so, yeah, but we need to clarify, like, if it's on the same footprint, if the
It would-
state's gonna.
I
use-
think the suggestion would be to not put it on the same footprint, to
Okay.
put it at the courthouse, to put it when that's part of the conversation needs to happen, where would be a good place to locate it, on separate completely from the DOT project.
Got it, okay,
Not confused with that in any way, probably funded by the county to get one in, and we know that the, funding for the four is around $1 million.
mhm,
So we're, you know, depending on, what it takes to get the power into a location to do that, we're probably looking at, you know, a couple $100,000, which we have the funds to do. And it sounds like we have a county need to really look at doing something along those lines.
one thing on the green space, I did have a brief conversation with Catherine. It sounds like there may be a little bit of middle ground in that I think the library was hoping to have, perhaps a little bit more green space, maybe just lawn, extending the lawn a little bit. The idea being they might be able to do some outside programming over the summer, their summer reading program and other things where they may need a little bit more space for kids, and they
That was-
talked about doing some movie nights and other.
That was
things.
not part of our discussion. It was poor slab.
Yeah, well,
So has there been conversations between the library and the city of Condon?
I don't know.
Because I think this was all initiated originally by the.
no, so it actually started with a safety committee
Okay.
need to replace the sidewalk, believe it or not.
Yeah. Way back
So-
when.
Brooklyn,
My question was just, what is the timeline for that kind of project? Because again, I don't think other partners have been addressed with that, not as a chamber representative, but as a Gilliam County resident.
Miranda, can you speak to the EV charging? I don't remember exactly what the timelines are, but it's out there a ways.
Is that, I think it will be like doing our kickoff calls over the next couple months, and then I don't think they project it to start until 2025.
So
We have time to fill out a report to, sounds like the city of London.
so it's actually county property, so it's a county request of city planning. So there would be opportunities in terms of the county court's gonna have to sign off on what the actual project's gonna look like. So there would be an opportunity to comment at an upcoming court meeting. And then it will have to go, because it's in the historic district of Condon, it has to go to city planning. So there would be opportunities on the city side as they're looking and approving it to also weigh in on what that plan.
Was your question about this project that we have in the works or about the other one that we're talking about today?
The green space, not the electronic vehicle, wherever you want to put that, awesome,
Okay.
sounds great. It's mostly just opposition to more green space in the city of Condon because we have too many green spaces, which I think is not true. I think there's always the opportunity, especially in Brown, to have more green spaces and culture and art, history. It's unfortunate that building was even taken down in the first place, in my opinion. So I think it would be nice to see something else in that space besides just a concrete slab or whatever it is.
But don't forget the courthouse is under construction right now, so I'm not sure about.
This would be out there. There's a lot of work to do before we could ever even start.
That's really what my question was how, like, the process is longer, if I have time to write the letter of support then.
There's a lot of, that library sees a lot of usage by kids,
Yeah.
especially in the summertime.
Yes.
Okay, so in terms of next steps, it sounds like I am guessing if we were doing another charging station, it would need to be on county property to expedite that. So would you like, are you suggesting that we look into putting some charging stations at the courthouse?
One, I think one will be adequate. One fast charging unit will
Okay,
be adequate to bridge the gap from here until we get this system installed.
so I think we'll start by reaching out to Columbia Basin to see if
What
we
power?
can handle that load at that area. And then I believe because Jeff had already worked on the other design, that it would probably be something that he could just,
And I would
Look at
encourage the
using some of
public,
that.
if they think there's a better location that we could work on and see if we could get, I mean, whatever would be best for Condon is.
the one at Columbia Basin, which is a slow charger, does get a lot of use
Yeah.
these days. Okay, so more to come on that. Let's move into.
How do we not drop the ball on that? Where are we going from here?
So, I will be following up first with Jeff and with Columbia Basin to make sure that we have, sufficient power up there to support that. Cause I know that that was an issue with the 4 chargers in the other place. I don't know if 1 charger would cause any issues. And then based on that, we would, figure out where within the county court or the county courthouse parking structure is the best place to put it and, Nathan.
Something we put on a new transportation building.
That's a possibility. but-
Potentially.
You're already building infrastructure there anyway.
That's maybe not a bad idea.
That's right, there's whatever.
Good idea.
They can barely make it into town and then start charging.
Hey, it's better than.
No, that's probably a really good location.
County transportation
it might-
building is what they said, if you couldn't hear them. They're good talkers.
Or even, First Park has a lot of service there because of all the RV spots.
Yeah.
And somebody had to hang out there for an hour, that's no big deal.
Yeah.
Enjoy the grass, we've already got green space there.
Good thoughts. Very good thoughts.
Okay, so we'll come back with some options. How about that? Maybe a couple of different options and then the court can weigh in and of course, members of the public are always welcome to come to meetings and weigh in as well. Okay, let's move on to new business. 7.1 is consider approval of request for extension of fiscal year 2022-2023 capital investment grants. Delaney, do you want me to take this or can you walk the court through these ones?
I can walk the court through if that's all right with you guys.
Yep, go for it.
All right, we have 2 grant extension requests before you guys for approval today. One is from the Port of Arlington for an additional extension on the grant for the Condon grade school building. They are still working on securing the additional grant funding and are just asking that their grant be extended to allow them more time to get all of those other things worked out. And then the Condon School District is asking for an extension on their capital investment grant for specifically for the roof portion of that grant. They have not yet been able to secure a contractor for that portion, and so they are just asking for an extension of additional time to let them find a contractor and get that project finished.
Questions on those?
And they only want to go till June 30th, not till the end of the year, so we.
Yeah, Lori, when I was speaking with Lori about it, she said they're going to prioritize this after the first of the year, getting this project wrapped up. So she felt confident that they could have it done by June 30th.
Okay.
Do I have a motion?
I move to approve the fiscal year 2022-2023 capital investment grant extension request as discussed, and to authorize the county judge to prepare and execute amended grant agreements reflecting the same.
Second.
It's been moved and seconded that we approve the fiscal 2022-2023 capital investment grant extension request as discussed, and to authorize the county judge to prepare and execute amended grant agreements reflecting the same. So further discussion, all those in favor?
Aye.
Aye.
Aye. Any opposed? Motion carries.
Break.
Okay, we are gonna take, because I have a feeling this could be a spirited discussion. Let's take, it is 11:36 right now. Can we take just a 10-minute break? Allow people to use restrooms and things like that, and then we'll reconvene to dive into 7.2.
Are you paying? This just wasn't.
Folks, come back to your seats, please. We're about ready to reconvene.
It's not the same without having Delaney put my little sticky notes in my. I'm
You're gonna
like
have to get
pulling
used to
through.
being.
Miranda, still recording. Okay, it is 11:45. The court is back in session. Okay, I'm gonna just kind of walk us through what I'm expecting to happen next. As I indicated before, there's no court order before us. I'm not anticipating any court action today. The purpose of this is first, we're gonna walk through just a presentation, a high-level overview of what process looks like. And then we've received a couple of letters of correspondence that I will read into the record. Then we will open it up to discussion and conversation with the community. So folks can just hold on to your public comments until we get through the presentation. And so I can make sure I get these letters read into the record as requested, and we'll go from there. Okay, so Miranda, can you share screen, please? Oh, first of all, before we jump into that, I need. Hey, Daryl, can you mute yourself, please?
Leah, right there. Yeah, Leah, our other commissioner, and
Okay, everybody's muted. To start off, I need to declare a potential conflict of interest. It is a potential conflict. It is not a current conflict of interest. The discussion and as it goes may turn it into an actual conflict of interest. If that happens, I will recuse myself at that time. This is based on an advisory opinion from the Oregon Ethics Commission, which I called. So wanted to let folks know that would be on the record as a potential conflict. Again, that depends on some of the decision points that the commissioners make on whether it turns into an actual conflict.
I cannot understand a word you just said.
So,
Find her a minute.
so if the board should decide to
Down there.
move forward, and if that decision were to take place during my term and have a financial implication to me, that would create an actual conflict of interest. If the board decides not to move forward, if the board decides to push it off to a later date, whatever, and it does not occur during my term, it does not create a financial change for me, then it is not a conflict of interest. This is per advice from the Oregon Ethics Commission. So I wanted to put that on the record so folks are clear that my participation may change depending on decision points that the commissioners make as they move through. Okay, can we do this so that this is full screen, Miranda? I think there's like a presentation mode where it doesn't have the little slides on the side.
Far left from the beginning.
Just hang on.
Just.
Make a comment real quick.
Sure.
And I completely understand, excuse me, I'll move up a little bit closer. Steve Schaefer, 211 West Penoyer, Condon, Oregon. Within the agenda, it really just covers discussion regarding the establishing. So really your comment in regards to, I'm not sure where that would go. You're not planning on any vote of any of this today, correct? So it's all discussion?
Right, as you'll see, as we get into the procedural overview, if the court were to move forward with this, they actually have to vote on an actual order. As you'll see, there's no order in a packet, like they would need to direct what they would like the legal counsel to include in an order. That would have to come back at a later court meeting.
Okay.
So there's nothing they can vote on today.
Good, thank you for
And I
that
think she
information.
said only potential.
Yeah,
Yeah.
again, yes, right. Again, I'll, reiterate my request that you table this agenda item and look at steps at moving back, rescinding. So just think that should be part of this conversation also. Thank you.
Okay, so as I indicated, we're just gonna go through a very brief kind of high level, so folks understand what we're talking about. The decision that the court is considering and receiving input on. So this is just meant to provide a procedural overview. Let's go on to the next slide. These are just some quick facts about boards of county commissioners in the state of Oregon. 29 of the 36 Oregon counties currently utilize a board of county commissioners structure. Of those 29, 20 operate under a home rule, 9 operate under a county charter. For those who are unfamiliar, counties who are under Oregon law allows counties to adopt charters, which set the rules. Basically, it allows a county to in essence, overrule some of the rules set in a statute. Home rule means simply that we are subject to the rules in statute. It means there is no charter that the county has adopted. So as you'll see, the vast majority of those counties using boards of county commissioners are operating under home rule, which means they do not have charters in place and have not gone through the charter process. The last counties to switch from the county court to the Board of County Commissioners, or BOC is the acronym, were Mora, which occurred in 2017, Wasco, which occurred in 2010, Wallowa back in 1999, and Baker in 1997. Most of the boards of county commissioners do use an appointed county administrator to manage departments and implement policies, programs, and priorities set by the Board of County Commissioners. However, that is not universal. In some counties, the chair of the Board of County Commissioners serves as the administrator. So there are, as I think Steve was saying previously, you've seen one county in Oregon, you've seen one county in Oregon. Each of the counties have adopted different ways of managing within their Board of Commissioners administrative functions for the county. So I want to just emphasize that point specifically because the Board of County Commissioners decision does not necessarily dictate exactly how administrative functions have to occur within the county. Those can be separate decisions.
Can I interrupt real quick?
Go ahead.
When you were describing the home rule and the county charter, what method does Gilliam County operate under?
So Gilliam County is currently a county court under home rule.
Home rule.
Correct. And all of the, I am almost positive all of the county courts in the state, I think there are 7 currently, are currently under home rule. County courts can also, counties can also adopt charters. They just don't usually. So the statute does not specify you have to be a Board of Commissioners to adopt a charter. Those are separate decisions in the law. Okay, let's move on to, this is just some potential pros and cons. I am sure the audience will have comments on pros and cons. This is just meant to sort of set the stage. Some of the feedback that we've received from other counties who have boards of commissioners on potential pros and cons. Again, it's not an exhaustive list. For some, the pros, for those who are using an appointed administrator, so somebody who is not an elected official, some find that provides some expertise and continuity in government functions as the Board of County Commissioners turns over. So you don't have a new boss every 4 years or 6 years if you're county staff. In those counties where the chair is not the administrator, it enables the commissioners to focus their time and energy on policy and addressing big picture community concerns. It potentially, depending on the structure, could balance power amongst the governing body. So making them all the same in terms of FTE responsibilities, balances some power. For some, and I have actually heard this from some community members within our communities, it may actually result in a better pool of candidates. There are many, actually, people who told me when I was running for judge, I would never want your job, but I'd love to be a county commissioner. And so there may be a possibility that folks who are not interested in the administrative functions and or couldn't commit to a full-time, but would be interested in a county commissioner position, you may see a difference in pool of candidates based on that. And then depending on structure, it could also result in savings to taxpayers. Again, that is based on policy decisions. That is, I think some counties will say that that has not occurred. Other counties will say that they have seen savings. I don't know that it's inherent in the actual structure that it's more expensive or less expensive. It has to do with how much you're paying your administrator, how much you're paying your county commissioners, any other support staff you have. Those are all policy decisions separate from this actual decision. Potential cons, it's a big change. I think somebody said this is a 100-year system. We're talking about changing. That means that a lot of systems that we have built are based on having a full-time judge and 2 part-time commissioners. All of those things would necessarily have to be reviewed and see if they still work under that system. Potentially the loss of a county judge title. I've heard that from some of my predecessors, that they have felt that that was a benefit to at times be able to use the county judge title in sort of compelling. Steve may be able to confirm this, sometimes compelling state agencies to do what they need to do to respond to you. Sometimes the title helps. So I have heard that. So I put that on there. The change from what we can tell, again, in consultation with our legal counsel, would most likely be permanent. We don't know that for sure. The reason we say that is because Oregon revised statutes clearly outlines a process from transitioning from county court to board of commissioners. It does not outline a process from transitioning from board of commissioners to county courts. And to our knowledge, none of the counties who have ever moved to board of county commissioners have ever attempted to move back to a county court. So there's no case law showing how one might do that. So I just wanted to put that on the record as well, that when our legal counsel sees that, they tend to advise us to treat it as a permanent decision because there isn't sufficient guidance from the legislature on how one might reverse it, and there isn't case law that might indicate a pathway through the court system. So wanted to put that on the record as well. Let's go on to the next slide. So the statute that we're talking about, the process, if you want to read that, by the way, this presentation is part of the court packet. It's online. So if you want to go back and look at those slides, more than welcome to. There's a link within that if you want to go directly to the statute. It's ORS 203.302 is the statute that authorizes the Gilliam County Court to abolish the office of county judge and establish a board of county commissioners. I, in full disclosure, am not a lawyer, so I did my best to sort of summarize that for purposes here. You'd obviously want to dig in and read the actual statute, and our legal counsel has read it obviously and interpreted it for us. So in a nutshell, go to the next one. This is kind of little font. Again, it's online, so if you want to go back and you can blow it up, but I will read it out here. So basically, a county court of any county who has not adopted a county charter, which we discussed earlier, and which the county judge has no judicial function, may order the office of county judge abolished and create a 3rd county commissioner. This is not on here, but it is also a possibility that that decision can be referred to the voters. It says specifically in statute. So where I will just make a note on the juvenile court specifically, there was some calls during December 6th to have that go before the county court or before a vote of the board, vote of the electors. In statute, it actually says that only the county court can make that decision. It does not have the same language that this particular statute allows for a referral to the voters. So just to clarify that, this specific statute allows for that referral process to take place. The juvenile court jurisdiction does not. Only the county court can give up that jurisdiction. Okay. So if the court were to decide to go forward, the process for doing that is an order. The court order would transfer all of the powers and duties of the county court and county judge to a board of county commissioners. The order is effective on the date specified therein, so the county court is able to establish what that date is. Again, that was in the reference to my own potential conflict, so it can happen at any time, really. If the order is to become operative in a year in which a county judge is to be elected, the following rules apply. And these are summaries. If the order becomes operative on or after a primary election, but prior to the general election, then those persons nominated in the primary election for the office of county judge shall be candidates for the office of county commissioner on the general election ballot. If that makes sense. So the primary election would say, oop, thanks, Kara.
Yeah, no worries.
So the primary election ballot would read county judge and list the candidates. And then the general election ballot would say county commissioner position 3 and list the candidates. That's the difference. If the order becomes operative on or after the general election, again, in a year that a county judge is being elected, then the county judge elect would take office as the 3rd county commissioner. So they are sworn in as the 3rd county commissioner created in the order, assuming that the order has become operative before the start of the term. So in a hypothetical, I'll use Morrow County as an example. When they did theirs, their court order said that it became effective at the conclusion of the current county judge Tolman's term. And so when Judge-elect Melissa Lindsay came in, she was actually sworn in as a county commissioner. She had a 6-year term, but assumed the office of county commissioner per the order that their county court had passed. So if the order becomes operative during a sitting county judge's term, so me, again, being the current sitting county judge, then the county judge, until the expiration of that term, serves as the 3rd county commissioner. So in a hypothetical situation, if the county court were to move forward and say it's operative during the next 12 months remaining in my term, my position would convert to the 3rd county commissioner. I would serve as a 3rd county commissioner. The order states, or can state, it does not have to, but it may, specify whether compensation for that 3rd county commissioner seat is different from the 2 existing commissioners. Could you mute yourself? Whoever's dialing in there. Last ending in 888. It can also specify powers and duties that are different from the other county commissioners. And it can also address whether that 3rd county commissioner would automatically serve as the chair of the county commission. In some counties, and I did get a question about this, I need to check with legal counsel. So some counties actually, you run for county chair. So they're mostly in the larger counties. So Multnomah County, trying to think of else, Washington County has an elected chair. And so some counties opt to have their chair actually be run and selected by the people. Some counties opt to have the chair selected by a vote of the board. Some counties can choose to have the person of most seniority. So the law is really open in terms of how the chair is potentially selected. It could be any of those things, and counties use all of those variations. Again, there's a lot of leeway for counties to decide what works best for them. The only exception to that is the person who is serving as county judge on the date the office is abolished shall serve as the chairperson of the Board of Commissioners until the expiration of the term of the office of that person. So for instance, if it were to occur while I was still in office, my position would convert to a position of county commissioner, and I would automatically become the chair of the commission until the end of my term. At which case, whatever the court determined was the way of choosing the next chair would occur with the new term in the new court. And I think that covers that bit. So this is, we're not going to be answering this question, but this is so that the court members can consider and also the public to consider. These are some of the key decision points that the county court would need to make if they're moving forward with this. First question, of course, being on balance, does the county court believe that converting to a board of county commissioners is in the best interest of the county and the people we serve? The second question is, does the county court wish for those administrative functions to be handled by a chair of the BOC or an appointed county administrator? These are things that have to be decided within the court order. If the chair retains administrative functions, is the position then full-time? How will the chair be selected? Is it by seniority? Some counties do a rotation where every year the chair rotates and it goes through all three of them. Sometimes it's a vote of the BOC on a predetermined schedule. Questions about the compensation for the chair. Will it be the same or different to the other commissioners? And then when is the best date for this conversion to become operative? It literally can happen at any point after a court order. It could be happened immediately. It can happen on a fiscal year, a calendar year, the end of the current county judge's term, or any other date that the county court selects. And then last slide. So if the county court decided to move forward and approve an order establishing the Gilliam County Board of Commissioners, it would then need to make a series of policy choices to implement the decision over the coming months. Some of those have been raised earlier, but these include and not limited to passing a budget that reflects a new Board of County Commissioners. That includes considering staffing structure, compensation choices for the commissioners. All of those things would need to occur. Choosing a reporting structure for department heads. Currently, the three of us each have a number of departments that are assigned to us that are not otherwise supervised by other elected officials. You know, so the sheriff supervises the sheriff's employees, et cetera. Creating and revising position descriptions to both reflect the administrative authority, any administrative authority changes, and also those reporting structures. Creating and revising county policies that reflect administrative authority, any BOC procedures, related choices. Again, our policies have all been written with the idea that there's 2 part-time commissioners and 1 county judge. All of those would need to be revised and considered. Reviewing and revising any 190 intergovernmental agreements. Those are the agreements for folks who are unfamiliar with the jargon. We have several regional agreements. So a good example would be our 911 center in Condon. That is an agreement that is signed between Gilliam, Sherman, Wheeler, and Jefferson County. And so the reason that is pertinent is in some of those agreements, it specifies that the quote unquote county judge is the representative of those that board. And so there would need to be adjustments and amendments made to make sure that Gilliam, it accurately reflects a change in Gilliam County's government structure. And then reviewing and amending other existing agreements as needed. To your point about IGAs with the state and other funding structures, we have, I think literally all of our departments probably are receiving state funds in some form or fashion. And so all of those potentially may need to be updated. Most of the agreements, I will say, list Gilliam County generically. They do not reference the structure of government. So most of those, it's likely would not need to change. So that just gives you a broad overview of process and things to consider. Okay, Miranda, you can exit out of that one. Again, the presentation is available online. If anybody wants to see that, have a copy of it, you're more than welcome. Before we jump in, Dana, I got some more things. You'll have your time, I promise. Okay. I do want to make sure we received, I'm sure Marta's in here. Oh yeah. Okay, so we received 2 letters from community members. I am going to read these into the record quickly. Then we'll go on to, I think, first questions from the commissioners on that process, if they have any, and then I think open it up for county discussion. Okay, first one comes from Susan Snyder. It says, please read into the record at the court meeting in Arlington. I'm unable to attend in person. My name is Susan Snyder and I live at 15189 Snipshin County Lane, Condon. As I explained in my testimony on December 6, 2023, I was born and raised in this county. My husband and I raised 4 children here. I'm the 5th generation of my family to live here, and some of my children and grandchildren also live and work here. I have lived in 3 other Oregon counties, Benton, Tillamook, and Douglas, and worked for 15 years in Wheeler County as secretary to the district attorney and county court administrative assistant, as well as serving as budget officer for 3 years. Before that, I worked for the USDA in Gilliam County, the Gilliam County Extension Office, as well as at Murray's in Condon. I also served on the School District 25 Budget Board and as a school board member and the Gilliam County Library Board. I was also the budget officer and staff secretary for the South Gilliam County Health District, Fire District, and Cemetery District. Oops, sorry. I was appointed about 20 to 25 years ago by newly elected Judge Laura Pryor to serve on a board researching the possible change to the county court structure. From the current judge, 2 commissioners arrangement to an arrangement with 3 to 5 commissioners and a hired county administrator. After several months researching this issue, talking to officials from adjoining counties, debating amongst ourselves, we recommended to the court that the current system of judge and 2 commissioners be retained. Of course, the judge position included responsibility for juvenile and probate matters. On December 6th, I, along with other county residents, suggested that the juvenile and probate judicial responsibility be submitted to the residents of the county for a vote. However, the court voted at that time to make the change to have these matters determined by the circuit court. And other than speaking at the court meeting, citizens had no, I think she meant chance, but it says change, to help determine this issue. I ask that you now consider taking this matter of the future structure of the county court to the citizens of this county for a vote. I do not feel this is a decision that should be made by 3 individuals alone. This matter will affect everyone living and working in this county, and as such should be voted on by the voters, not determined by just 3 individuals. I also feel strongly that no matter what happens, the judge's salary should be reduced to the same amount as the 2 commissioners. I do not think that this county is large enough to warrant hiring a county administrator. If, however, the judge returns to being the actual county administrator, which would require this to be a full-time position, the salary issue would need to be reconsidered and adjusted. Thank you for your consideration. The second one comes from, and she doesn't sign it, but our email address, it's from Susan Snyder. The second one comes from Marta Michaelo and reads, Judge and Commissioners, I've been spending time thinking about what is currently happening in our county government. I've chatted with folks, read social media, looked at statutes, watched the county court meetings, and what is most concerning is the push to make big changes to our existing county structure without taking it to your constituents, the voters. Key to me is you are our, quote, elected officials, end quote, promising to always consider what is best for the county and talk with the people. This seems extremely lacking in this particular case. The question is why? Why the push? Why make this happen in 2 weeks when it's been in place for generations? Why not take it to the voters, at least hold information meetings to educate all why this direction is correct for our county? I'm told there are serious problems in our courthouse. While I'm not there, I've seen the statistics of the number of people who have left the courthouse in recent years. 15 employees, a staggering number. How does this courthouse dynamic change when going from a 2-person commission with a judge to a 3-person commission? I understand you, the current 2-person commission and 1 judge, are wanting to add a quote, and quote, office manager, end quote, for a big salary to manage the courthouse. This office manager will answer to the quote, new, end quote, 3-person commission. The same people who currently make up our county court. You, what changes? If it's true we are truly moving to a 3-person commission without a judge, which I am not convinced is truly legal, then why now? Why not look at the big picture and go to a 5-person commission? Embrace the time it takes to do it right. If in fact it is confirmed legal to change the 3-person commission, does Gilliam County really want to give up their jurisdiction? Why? What are the motives? To me, very unclear. At this point, I'm asking for the county court to step back, review the motives for a change, and if a move to no judge is what the people want, then move to a 5-person commission, not a 3-person commission. Thanks for your consideration, Marta Michaelo. Okay, so before we open it up to the floor, I just wanted to ask commissioners on the process, the overview process that you have, that you saw. Did you have any questions? Is there additional information that you would like me to bring back? Just to start off before we open it up for the broader.
Yeah, I absolutely have a question and I lost it.
Okay.
Came down.
Do
I
you
will
want me
gather.
to open it up to the public and then we can?
Yeah,
go
I
back
think
and
we
read it?
can. there was something that, struck me that I need to ask. I don't remember what it was right now.
Okay,
So I was just gonna add, so for information, there actually is
Oh, I do remember.
only 6.
one second, please. Sabrina, can you mute yourself, please? Go ahead, please.
Okay, there, because that came up, and there actually in the state, there's only 6 counties that actually have an elected chair by the voters, so.
And what counties are those?
Baker, Clackamas, Wallowa, Hood River, Multnomah, and Washington County. And the ones that have 5 are, let's see, Benton, Classop, Hood River, Jackson, Josephine, Lane, Multnomah. No, that's not true. Never mind. That's
Those
not
are-
right.
Those are,
Because Umatilla only has 3. So Clatsop has 5. Lane has 5. I might not have the other page. I think Multnomah has 5. Hood River has 5. They're all volunteers in Hood River. So there's like 5 or 6 counties that actually have 5.
and some are paid employees, some are volunteers. Again, each county makes its choices.
Yeah.
My question was, if a decision was made to move to a board of commissions and you set a date out in the future, say the start of the fiscal year, that decision is in place at that point, that's going to happen on that date. Is there something that can back up between that decision and when that happens?
Say that again. I'm not sure I understand. your question.
So you decide January 15th, you're going to do this and it's going to become effective July 1st at the start of the fiscal year.
Can you repeal your?
Can you repeal that decision or can that decision be changed between the 15th and the 1st of July?
You can.
Okay.
Yeah, so Crook County, by the way, I think I said 29 counties are, Board of Commissioners. Crook County is currently having this exact same discussion that we are. They had a similar situation. They talked to their county clerk, and I can't remember the date, so don't hold me to this. I believe they gave themselves about a 5-year window from when they passed the order to when it became effective. In the time, in that 5 years, they had new commissioners come in who rescinded the order because it had not become effective. So when I had said that we think it's permanent, that's under the assumption that it becomes effective. But Crook County does have a situation and where they had turnover, I think 2 years after they made the decision, the new county commissioners rescinded that particular order. And that is why they remain a county court at this point. But they are in the process actually, as we speak, I think, making
I talked
a decision about whether they want to.
to Judge Crawford about that.
Yeah,
They have no judicial left
They're not
there at
doing
all.
any judicial.
they removed their judicial,
It was in the 90s.
I think it was in the 90s. Okay, I'm sure lots of people have questions, lots of people have comments. Here's what I would like to do is make sure so that we can make sure that we get to everybody. That once you state your comment, like, let's let everybody else in the room have a chance to make sure that they also get their comments. So I'm gonna try to not double until everybody's had a chance to have their say the first time, okay? Again, state your name, please, and your address. If you are in the back, please come forward so that for our discussion earlier, our folks who may be hard of hearing have a better chance of hearing you on the mic. Who would like to start? Go ahead.
Jenny Newell, Blaylock. And anecdotally, I noticed we spent more time talking about a recharging station today than we talked about jurisdictional transfer previously. Observations from recent court proceedings prompt me to request the courtesy of completing my remarks without interruption. I believe this discussion is ill-timed and orchestrated to be so. I believe the recent matter of juvenile case transfer was as much about doing away with the judge position as it was juvenile or probate adjudication. I believe today's discussion and its timing have their roots in Judge Patino's filing for county judge. Although I cannot find it in county court records, the skids appear to have been too well greased in advance of the unanimous decision to transfer permanent jurisdiction. Ignoring suggestions to do so, not one court member either declared a conflict of interest or recused him or herself. Not that it necessarily matters at this point or to this court, but for others, I am adamantly opposed to replacing the county judge position with that of a third commissioner. I'll return to my reasons shortly, but first I ask you, as I ask myself, why did the incumbent judge run for the position if she didn't intend to perform the duties? Or was that determination made after she was in office? If after, did she abdicate her responsibility of her own volition? Or was it a court decision? If it was a court decision, did the judge abstain from the vote? What was the process resulting in Gilliam County's agreement to pay upwards of $30,000 annually for juvenile adjudication? When that $30,000 responsibility was contracted out, was the judge's salary decreased a commensurate amount? And if not, why not? As to why I oppose abolition of the county judge's position, 1, 3 commissioners, given they are part-time, leaves no one accountable for the daily conduct of business. I'm not suggesting work wouldn't get done, but if it didn't, who would we, the voters, hold responsible? 2, I oppose the county administrator for the same reason. Who would the citizens hold accountable? Make no mistake, county administrators answer to the county commission. They therefore need to satisfy only 2 people. They don't answer to the public. So as much as they satisfy those 2 people, they are golden, untouchable. There is nothing to be gained by losing local control and little to be gained by listening solely to the experts, as our court has a propensity to do. Nor is there anything compelling in the fact that other counties have abolished their judge position. Remember, others drank the Kool-Aid.
Dana? I think it'll catch you there, Dana. You don't have to come up if you
Oh,
want.
no, that's okay. You know what? I just love y'all watching me walk, and just so y'all know, don't get in my way, because I've already killed 3 people this morning.
I moved my toes.
Okay. Okay. I think that I've made it pretty clear, because I've only come face to face with you people about 3 times. But I walk away with the same impression. And I said it again this morning. Self-serving, underhanded, deceitful, and manipulative. I see 3 people up here that seem to be making all the decisions. And I don't see a lot of indication that you actually listened to our input. When it came to the December 6th meeting, I was left feeling that that decision had already been made. We were just getting lip service. But I'm also getting the same impression from this. that this is somehow coming out of three people who are having meetings with no transparency. There's obviously discussions going on. But I've not seen documentation, I've not seen transparency. All of a sudden, it appears on an agenda and we're supposed to comment on it. We don't have a lot of time to do our research. Okay, but we have a couple of days to comment on it. Okay, and I object to that strongly. And I just pointed out, I'm not gonna go everything I have here, because I'm gonna try to keep this to 3 minutes, okay? But for instance, you know, when you're changing a form of governance, there has to be a draft. There has to be a structure. Okay, you can't just come in and say, we're changing it. Somebody has to draft what those changes are. And for instance, it says here, most Board of County Commissioners utilize an appointed administrator to manage departments and implement policy. That's great. Who appoints that person? And most importantly, who can terminate that person? Because surely you don't mean this to be a lifetime appointment. This is the sort of thing that I want to see draft information on. Okay, I'm gonna bypass it. I think you're gonna have a meeting in Condon. And I'll see if I can't get some more fascinating things to say to you. Okay, and it says here, the county court, oh no, let me go to that in just a minute. Okay. Choosing reporting structure for department heads, creating and revising position descriptions, creating and revising county policies. Every one of these things needs to have a draft. Your public needs to see what structure you're proposing. And not just a draft to be put up on the county website, a draft that can be published in the newspaper so that the county can see what it is you're proposing and what it is you're doing. Okay, now that's if this should be implemented. And it says here that the county charter, something in which the county judge has no judicial, the words are lost on that. What was that last word?
No judicial function.
Yeah, thank you. Okay, I also ran the internet, and I'm also not an attorney. I just want you guys to know that this information is not difficult to find. I also found ORS 111.115 and 111.075. And what I noticed is that it says probate jurisdiction vested. It used that word, vested, in Gilliam, Grant, Harney, Malheur, Sherman, and Wheeler. Okay, now you may transfer any probate to a circuit court, but it says in there that it has to be transferred by order of the county judge. This is a statute, you guys. You can't just change this with a motion. This has to be addressed. And I get the impression that you guys didn't even know this was out there. My goodness, when I started doing research on this, this was one of the first things that popped up. Okay, but again, I get the feeling from you all that you have already tried to decide this. I don't like that impression. I want to see drafts. If you get beyond this ORS 111.075, I want to see documentation. If someone is in fact going to bypass this, I want documentation. I want to see something in writing. I want to see a name, a title, an address, and a phone number. I don't want you coming in here and saying, oh, but I talked to somebody on the phone. No, I want to see something in writing. If in fact, for some reason, this does not apply. But if this applies, you can't change county government. You can't change it. Because this demands a county judge. And I don't like the timing of this. I don't like the fact that you timed this just before Christmas vacation. Boom. I don't like the fact that you're timing this so that Liz may not have to file and may not have to run for re-election. I don't like this timing. I am not comfortable with this. And I get the feeling that it's coming from the same three people. Do we actually have input? I guess we're about to see. Thank you.
Who would like to go next? Kara.
Hi, I'm Kara Davis, again, your district attorney, and I think I'm the only lawyer in the room. I said this last night, I tried to stay out of the probate question because it's not my lane, but my reading of the statute does make it seem like the county court might not have any authority to transfer the probate matters. I'm sorry, I didn't weigh in before. I just honestly thought nobody wanted to hear from me, and then people started asking me. So I looked, and you go back to statutory interpretation. For those of you who don't know, my first job out of law school was as a legislative attorney. So that is what I did, was statutory interpretation and legislative drafting. In Oregon, our main case on statutory interpretation is PGE versus Boley. And the main rules are you don't omit language which has been written into a statute, and you don't write in language which has been omitted from a statute. And when you look at those two statutes that have just been cited about probate jurisdiction, they say nothing about the court's ability to be able to transfer that jurisdiction. If you look at the juvenile statutes, it specifically allowed the county court the ability to transfer the jurisdiction. So my belief is that if somebody were to challenge the court's decision on this and it went to a hearing, that there would possibly be a stay put on the matter while it was reviewed by higher courts, because I also checked the annotations of the statutes, and there has been no litigation that I could find on this particular issue. And I can't actually find any case law in the state of Oregon where these two particular statutes have been challenged at all. They have been cited in about a grand total of, I think, like maybe 6 or 7 cases, just kind of offhand for no particular reason. So I can't find any cases. If the county court has any cases that their county council or the council they used in Eugene, which, by the way, go Beavs, not Ducks. I would love.
What'd she say?
I would love.
Leave that out of
I'm just saying, why did you go to the hippie jurisdiction, Dan? Why with the hippies?
Sorry.
But I haven't seen it. I haven't seen it. So I do have concerns, because while you guys do have the ability to abolish, we don't have a charter. You do have the ability to abolish. It's only if there are no judicial requirements or duties or functions for you, Elizabeth, and I'm not sure that you can get rid of the probate. And that makes me scared, because I know there are statutes that say if you don't have somebody contracted, I'm the one that has to bring this suit, and I really don't want to. I'm good at crimes. I'm not committing them, prosecuting them. That's what I'm good at. That's what I'm good at. So I would really like clarification on that. If somebody does have some case law, I'm not asking you to have it offhand, but that would help me. I am also concerned about that myself. So that's it.
So I have a comment.
Yeah.
In my understanding is in 1972, the Oregon legislation, which at that time, John David Burns from Gilliam County was the Oregon Senate president, that the legislation moved to move all because everybody was a county court. They went to move all the judicial stuff to the circuit court. And then my understanding is then, because the circuit court, we're talking 1972, didn't want to travel to the rural counties, that it remained, the judicial part remained in those counties. And I just wonder if then did they have to go back and say, yes, these 6 counties, which I think somewhere along the line, they must have took Crook County out of it because they moved away from it. Did they just do that so that to make sure that they had legal jurisdiction, or do you understand what I'm saying?
I'm gonna say, this is a big caveat. I was born after 1972. So, but my dad was if you guys don't know, my dad was the Republican Party chairperson in Oregon back in the seventies. So I have a little bit of history, family history, and just unrelated legal research on things that were going on. When they were, I think there was only been one amendment made to that statute since 1969. There might have been two when I was checking. I was able to get that far. There has not been a lot of amendments, and there hasn't been any amendments more recently than 1995. So when they were kind of parsing this out, we didn't have the ability to do Zoom. We didn't have the ability when we had an emergency hearing that needed to happen for a child that needed to go into care. Like, the best we could do is telephone.
Yeah.
And that's the best we could do. So yeah, there is a historical reason that we have those things in place that the state legislature might not consider necessary anymore. But I will tell you, when you're interpreting statutory language, the last thing you look at is legislative intent. You look at legislative intent only when the words can't possibly mean what they say, or when they are in conflict with each other. Originally, when I started looking at this language, I thought there was going to be a conflict between the two statutes. Because I thought, like, the juvenile statute that specifically allows for you guys to get rid of the county court hearing those cases, I thought there would be that in the probate too. And so then you have this, I thought that's where the difficulty would be. But this is very clear. The ability to abolish the court only says when there is no other judicial function. And every single county that is listed in that probate statute still has a county court. And I think we're about ready to be the only ones. Am I wrong on that? If Kirk County goes through, are the only courts that have
There's only three, I think.
three county courts. So the only thing that I would say that you would then need to look into.
Wow,
There's six.
Right.
Harney kept the
Yeah,
probate.
there's 6 counties in the statute.
Yeah.
Well, and so that's part of what backs up my legal reasoning, is that's the reason those are the only counties left with the county court system. I do realize it's very hard to get legislative movement for 6 counties, but I think that might be where it needs to be. And it might be outdated reasoning that was used to get us there, but that's the statute we're stuck with until there's a legislative change to it, no matter what the intent was.
Because there would, at one point, there was a lot of counties that changed in the 90s, around that
And
time.
Wasco changed in the early 2000s.
Yeah, 2010, I think. But they had to have one time been listed in the same kind of a order
No.
that.
No, so I was
they
in
didn't-
the Dalles, I worked in the Dalles as a deputy DA when it was both a county court system and when it was a county commissioner system. And the reason and Dan Erickson was one of the last, I don't know that he was the last county judge, but he's the one that hired me as a deputy DA the first time because he liked my dad, which is both a blessing and a curse of the county court system guy. I mean, I'm a Nepo baby, but what you have is that it no longer served any judicial function. And what the Dalles needed, Wasco County was having a lot of financial problems by eliminating the county judge position and turning it into a county court. They did hire a county administrator, Tyler, who I've told some of you last night, he's a dick, but I love him. He's our dick over there. And he shaped it up. He fixed the problems, he did fix the problems. Did he make it more bureaucratic? So no county judge would ever hire me again, just like that. It would be open and competitive instead of, hey, Kara, come here. Yeah, I mean, there's changes, and that's for you guys to decide what you want and how you want it. But originally, we were all just so small and disparate, and Oregon's such a big county that was how ours were formed. And then when they put protections in place for the really rural counties, it was so Salem couldn't force them into a different type of government. And so it was protection for that. I can do it, but I'll take the credit if you want me to. But that's what it was. And I mean, there's definitely pros and cons when I've worked in both systems for the same county. There's definitely pros and cons, but I think that was very much a response for people not wanting to have probate taken out of their hands, which is a blessing and a curse, guys. So just so you know, that's just my thoughts about reading the statute.
Thanks, Karen.
Thank you.
So when we talk about this, when we talk about that statute that names those 6 counties, where does Morrow County fit in this? Who has done this recently?
So Morrow County is not on that list. They are on the juvenile list. And so when they did their conversion, they gave up their juvenile, not probate, because they did not have probate when they began their discussion.
Okay.
So they didn't have it anyway to begin
Who
with?
was? how
I mean,
did they-
Hadn't had.
Back in the history of the
Well,
state, they all had it
And
at
I
the very
practiced in
beginning,
that
but
judicial district for 17 years. So I practiced in the Pendleton Morrow Judicial District for 17 years. And the entire 17 years I was there, they didn't have that probate jurisdiction, but they did have the juvenile jurisdiction. And there was a lot of pushback from the local attorneys to get rid of that. It got to a certain point, like where the firm I worked at, we refused to do juvenile cases in Morrow County because they were in county court and not in circuit court. So they were struggling. That's just a background on what happened in Morrow County, if you're curious. Part of it, just a small part, but part of it.
Yeah.
okay. Who is next? Go ahead, come on up. Can you,
I have a very loud voice, so nobody typically has a problem hearing me.
I'm not so sure though that the mic can pick you up.
Oh,
So if you don't mind
it's
coming up,
fine.
that would be great.
Connie Anderson, 14906 Heritage Lane, Blaylock. What I'm most interested in is what Denny has said, what Marta has said. It's getting answers. You know, we've seen the same blank faces, but we want answers as to why. Why the timing? Why the change? What is going on? I think that's of most interest to me, is to get answers, not just bouncing words off of blank faces. So that's all I want is answers. And I'm sure I speak for everybody in here who's asked the same questions and hasn't got any words back. So that's all I have to say is I would like to hear information from you. Why? Why the time? What's our motivations? I'm sure you've discussed it, but the public doesn't know.
We actually haven't.
We have not
Well-
discussed it prior to what has been said.
I mean, if it's-
I have no idea where they're at.
If it's about to be
What do you mean
decided
how?
on, then it's been discussed.
No, I put it on the agenda at the last meeting. I asked to have it put on
At
the.
my urging, I might say. At my urging, I might say.
Don't.
And don't, I know I'm speaking out of turn, but don't you
Okay.
hunger for answers and discussion?
Hold on. You in the back, if you could just state your name, you had a question. Hold on, please, Connie.
Stay there.
You can stay
I
there.
want you
She
to
just
stay.
has a question, I think, related to you. Go
My
ahead.
clarification question, Aaron Reedman, 68040, Highway 19, Arlington, is how have you not had any type of discussion? And it just got thrown in and then you were gonna do this? How, like, you put it on to be now, just so you decided this, but you prepared all this for it today. You can't say there hasn't been some discussion of this. You can't say that you are literally just pulling it out. Boom, here it is.
No, so what happened was when we were in discussion on December 6th during a public meeting, there was some public comments related to how this impacts potentially governmental structure. And at the time, it doesn't. I mean, we're still a county court, still a county judge. Commissioner Shannon had requested as part of that discussion, and it was in an open public meeting, that I add this to this agenda, which is, of course, perfectly legal for him to do. And so the presentation that you have was based on the request from him on December 6th, that we have a discussion about the governmental structure. And so what you see in the PowerPoint is basically me doing my homework and going through the statutes and talking to legal counsel and just trying to give the public an overview of what the process is.
So Commissioner Shannon came up with this idea.
Now, can I speak to that? This has been an ongoing discussion in the community for the 3 years I've been a commissioner. There have been lots of people that have talked to me about this. I've had some discussions 2 weeks before that were 2 or 3 weeks before that were driven by the county deputy clerk situation, that were driven by members of the public on why we didn't do this. Okay? This has been kind of on my radar screen. I have text from Judge Patnode from December 1st of 2022 when she suggested this. This is not something that just came up out of the blue. This is something that's been on my radar screen for 3 years. I didn't know a pathway to get here until the juvenile director made the request to move juvenile, and I see a door opening.
Cause it could.
And in the back of this, I will explain where I'm at. I have that here.
Is what
I have,
we all would like to.
and they don't know what my feelings are about this or what my motives are. But I have some motives that yeah, I will share with you. I hopefully in an organized manner because I have a lot. And, but this is not something that was planned or dreamed up out of some conspiracy behind public's eyes. It just wasn't.
Then why didn't you put all of those things together and put it on the agenda of why that's happening instead of this backwards way of doing it?
It's not a backwards way.
It's not
So,
a step forward.
so the conversation, while the jurisdiction was in place, as you've heard multiple people just say, the statute, the county court couldn't even have considered a board of county commissioners until a decision was made about the judicial jurisdiction. So it would not have come up because it's not a possibility up until the decision that was made on December 6th. So, and
It could have been discussed.
hold on,
It could have been
I am
discussed.
not done talking. So if you
It
could
could
just
have
take
been
a minute. During some of the public testimony, there was at least one, maybe two people during December 6th who specifically said, we would like you guys should be looking at making this a county commission. And so Commissioner Shannon said, in context of those deliberations, yes, it is something that we should look at. And I clarified for him, if you go back and look at the video, I asked, do you want me to put it on the next agenda? Which is my role as the current county administrator, is to put up this agenda and make sure all of the packet material gets out and all of that kind of stuff. And so part of that due diligence that we do routinely for everything that comes up for the county court is that me and the county court staff then talk to legal counsel. We start gathering information. As you've heard today, because former Judge Schaefer asked me this question, there is nothing before the court that would allow them to make a decision on this today. And so part of the reason, Connie, I think you don't have answers from us is that there was a request made that folks have a discussion about what this would mean and learn about it. And so I suspect that hey, Jen, whoever is on their phone, could you mute yourself, please? Or Miranda, if you could mute them. Is I'm not sure that everyone has landed. So part of this discussion is to get feedback that I think would shape people's views on what should happen next.
I think a positive way would be when these questions, such as Marta's letter, such as when people have these questions that they put out there, is perhaps we get answers back.
Just a couple of things, because one thing that been educational for me this week is I didn't know until I see the packets what this presentation today is even about. And I missed some things that I saw today. I've been learning along the way on what she put together that I didn't know she was gonna put together. Okay, I mean,
That's understandable.
Yeah.
That is understandable,
Yeah,
and this is
and
the
I'm-
route you go.
we're
But when
going
there's
through the.
questions, I just would appreciate if there could be some answers back.
I think that's a process, and whether we listen to all you first or we answer you after every question, you know, and we've determined.
It might eliminate some of those questions.
You
if
know,
there were
and
answers
I
back.
personally am here to listen to people and, you know, find out people's opinions. But when you people sit up there and say, criticizes, like, oh, you just sit there with blank looks. I mean, the criticism is doing nothing for me,
Well,
so,
that's what we're getting back.
but please,
As
if
well.
you
I
have
understand that. I'm trying to
legitimate
go through the
comments
process.
and stuff, I am more than happy to listen to it. But
But that
I'm
is what we
getting
get back.
a little tired of the criticism.
Do something about it, do something different.
What would you suggest?
I don't know, we signed up for it, so we take it.
That's how you were.
I mean,
It's part of the
this
deal.
is what we're doing right now. We opened it up to discussion. We have nothing in front of us to make a decision, so.
Put it for a vote to the electorates.
But we can talk.
That's what we're asking.
I'll let more people
Hold
ask
on,
questions.
hold on.
You have to stay again?
You
No,
cannot.
no.
Steve, don't interject right now. Connie, are you all done?
I am done.
Okay, you can go
Yes.
back to your seat.
Thank you.
Steve, why don't you come up so we can see you? And then I got you over here in the corner. And then you, okay.
I'm gonna have to have a restroom break if this is gonna continue.
Understand.
No coffee.
Again, Steve Schaefer, 211 West Penoyer, Condon, Oregon. I think what has really created the problem is that there was a situation, within 7 days, the agenda came out. Prior to November 30th, I believe, was the date that it showed, or should have been closed. And then on December 6th, you're making the very first step that it takes in changing our form of government without anybody's input whatsoever. I don't believe all these people realize that the moment you ended that judicial duties, that was beginning to end our form of government. And they're just really beginning to find that out now. And that's why everybody's so upset with you, is that, and why they're throwing spears, Leah, and making you feel very uncomfortable, is because they didn't know that this was going to be happening. And no, there wasn't enough information that was put out. So people understood that when you ended those judicial duties, you were in taking the very first steps in ending our form of government. Go ahead.
The process is the process that I'm going through because I didn't actually know where this is going either.
Mhm.
It's been an educational process from the first request from the juvenile director. This whole thing has been, to me, it's about, this has been something that the public has considered. And is the time to look at that. And this is just where it's led me down the road. I have had different thoughts about this over the last 3 or 4 weeks, like you can't imagine. I'm just, you know, as I process all this stuff. So, I have some really strong opinions about urgency that I will share.
You and I have talked about
Yeah,
that.
well, and some of those are even, I think, more profound than what we talked about in my mind. And I'll share those, but, yeah, this is a process for me, okay? I would like to have you trust me to go through the process.
Correct. So in all fairness, this is something that Liz talked about, during our campaigning together. It was there. It was brought up again. This is my issue. It was brought up again on the December 6th meeting by an individual who come in and said that got a group of people together and decided that they were going to look at the changing of county government, take a look at the people that are in those positions. And so I feel that is really the foundation of a lot of this. And my concern is it's that small group of people that has your ears.
But
I'm concerned that it's that small group of people that has your ears and not the rest of the constituents in this county.
Okay, can I speak to that just a little bit?
Sure.
Because I see who's here. And I see who's on Zoom.
Mhm.
And we can argue about it's a big group or a small group. But there's 1,400 voters in this county. and we're talking about 40 or 50 people here, maybe at the most, including Zoom. And you're talking about a small group of people that you haven't defined the quantity of. So we're talking about little bits of people, little groups of people with opinions, and we're supposed to weigh in on that one small group's opinion and they get the whole power, or do we? I mean, there's a whole process here, and that's why you said early in this that phone calls are not the way to answer this. I don't know how to be any more transparent than ask you to call me, which I have gotten some calls and some really good conversations over the last week where I could walk through some of this. But that's part of the process in being transparent and being available to have those discussions, which help me form my opinions. But they're not necessarily just coming from this group of people. They're coming from part of them from the other 1,400.
Yes, believe me, I've been in your seats. You're not telling me anything. This is, that's.
Well, and there was, I will go back and say there was a lot of discussion at the end of Judge Pryor's term about going to a board of commissioners with like 5 commissioners. There was like tons of conversations in the communities about that at the time.
Which again,
I was very familiar with that conversation, had a lot of them with.
Yeah, so this
Judge
hasn't just
Shaw.
popped out of the blue.
Had a lot of those conversations with Judge Shaw and also Commissioner Weimer at the time.
Yeah.
So,
Yeah.
that's, again, it was, to me, these were things that I would have loved the opportunity to debate. Social gathering, I don't really care what it is, this group come in, this group come in, this group come in, everybody comes in, and we debate this.
Yeah.
We talk about it, and we come up with a consensus.
But isn't,
We come up with a consensus, and that group that, made the statement that individual made that statement, that group comes in and gives their opinion. And all of us got the opportunity to be able to discuss what that might be.
so I totally buy into, and I understand, and you've sat in this chair too. There are a number of people who weigh in outside of this.
Oh, absolutely.
I mean, they will
Yes.
catch you in the grocery store, they will, all manner of places, which is great, by the way.
It's one of the reasons we live in small communities.
Right, so, but what I'm a little confused about is, to me, this is part of that public discussion. Like, what we're having right here is the public discussion, and so I'm not sure why there is this negative feedback about having the court have a public discussion. I mean, look at how many people showed up. I want you guys to put your hands down, please. There's other people in the queue ahead of you. And so I think this is the give and take that needs to happen, right? There's a reason we have public meetings. There's a reason that it's advertised. Obviously, all of you knew that we were having a discussion. Well, I've already indicated that this is probably one of several discussions. So I guess I'm a little unclear on this particular issue, the Board of County Commissioners. This appears to be fact gathering and input gathering that your elected officials should be doing. So I guess I'm a little confused on why we aren't actually achieving what you just stated that you wanted us to do, which was talk to people that we haven't talked before, because you guys are all here. Not all of you are regularly here at county court meetings. So in fact, most of the time we have like one person, usually Jed's there, representing the court. So I guess I would just suggest to folks, like, I think people are acting as if this is a done deal. To Dana's point about documentation, there's no documentation because a decision hasn't been made. No one has given me direction on what they would like to have come back to the court. This is the first discussion, and so.
You have documentation before the decision is made so that people can see the structure you are proposing.
There isn't.
We haven't got there.
We haven't gotten there.
I know we're not there yet.
This is the part of the conversation where we get input, people's concerns, people's worries.
One of the things that's necessary before you can move forward.
Dana?
There has to be documentation.
We're gonna have Steve.
Can I allow me to finish? If you don't mind, I wanted to definitely intake or swallow what it was that you were basically saying. And again, though, I'm gonna reiterate, I'm gonna go back and to the December 6th meeting. It was at that time, now again, we have two counties, neighboring ones, Wheeler and Sherman, they're still keeping the court together. Contacting those individuals, they're gonna continue giving it to circuit court. They didn't make a move. If they're not planning on making a move.
They're pretty quiet about what they're doing, Steve.
Oh, he said they're pretty quiet about what they're doing. Yeah, they're, at this time. No, they are not.
Currently.
Joe,
Okay.
Steve's
again,
got the floor right now,
you
please.
made a decision to eliminate that position, which is the very first step in getting to the conversations that you're talking about today. What we're saying is we wanted to have the input at the time prior to you eliminating these judicial duties, which will eliminate a court.
Yes.
Form of government. That's our point. You moved without enough input, and as I stated in mine, I believe not enough information. Are you okay? I love what you're doing here today, Liz. I
Got it.
really do. This is great. It should have happened prior to December 6th.
Okay, thank you for that
Thank you.
clarification.
Thank you. Sorry, again, it should be grandpa's voice and it became coach's.
I want to go over here. This gentleman has been waiting. Do you still have your comment?
I do.
And if so, could you come up here?
Sure.
Just for fun.
My name is Todd Turk, 1250 West Second, Arlington. I have a couple of questions that have not been answered. First of all, I understand that this conversation goes back years, and that's fine. It's wonderful to have conversation. What I want to know from each one of you commissioners and judge is, what do you benefit from? And how does the community benefit from the decision of or the process of going to a commissioner type site? How do you see it as a benefit to the county? And most importantly, what was the impetus to make you do this now?
Okay.
And I'll leave you to discuss that and
Okay.
answer that.
I'm not gonna discuss it. I'm gonna explain that when we get done with public opinion or public comment.
Oh, I'm just kind of hoping you could do it now, because it leads into what the other questions I have.
It's
I can't do it.
important for us to understand the genesis of your decisions
Go ahead.
and your processes and how you got there.
I would suggest maybe a break for about.
Yeah, I was gonna say, I can't do that without a break.
That's fine.
Okay, so,
Understand that those questions are out there.
okay, so, we have had a request for a temporary recess. It is 1:03. I'm gonna, just temporarily pause proceedings. Can we say 1:10? There's enough people, I'm sure, who needs to use the bathroom, so we will reconvene at 1:10. And then we'll jump into the question that Mr. Turp just had of the board. Do you want to unmute us, please? Okay. All right, folks, it is 1:11. We're gonna come back into session. We left off with a question, and so commissioners, do you want to answer that now? Do you want to?
I'm okay with, if you guys will bear with me, starting a discussion from where I'm at. I don't know where they're at. I know where I'm at. And, I'm a little mind fogged. I did testimony in Salem with the Health and Human Services deal on Monday, and it was high pressure and a lot of work, and this is just piled on top of it. So what was that? I said I did testimony in Salem Monday afternoon on with the Health and Human Services Summit meeting down there, and it took a lot of prep, and I'm trying to prep for this, and so I have typed out a bunch of thoughts, and I'm hoping to come out somewhat organized. So if you'll bear with me and anything you got more questions on, because if it's not clear enough, please ask, and I'll try to go into some more detail, but I'm struggling really, really hard with transparency and not publicly humiliating anybody. And it's a really hard road to walk. And with that being said, I'd like us all to consider some things, and there's some values I try to live by. And one of them is to place principles before personalities. Are we doing that? Are we tied up in the personalities and we're not really talking about the principles, which are the fundamental things we need to do long-term? Personalities are temporary and short-term. I try to examine my motives. I go through a process to peel back the onion and keep seeing why, what is that motive at the end of the day? I try not to participate or try not to be a part of a selective participation where I'm just participating when I want to hear what I want to hear. It's important for me to not run on hearsay, but try to get the facts. And I think finally, and the most important part of the discussion that I have is, do we really care about our employees here in the county? Because I think for me, that's what this is all about. Quite frankly, this situation's got me really boxed in, and I'm in a no-win situation. I'm just there, and that's okay. That's what I signed up for. That's where I'm at, and I can deal with that. There is a win-win for the county in this, and I know you don't see it. And I'm unwilling to get down and muddy. I want to take the higher ground to get there, but I'll try to get there the best way I can so you can understand. I understand the desire to get this to be more in the hands of the public. I get it. I completely get it. But for me, with some things that are occurring today, what we're having to deal with from here, it's simply too late. That's my opinion. We're in trouble. We're close to a crisis, and I'm concerned about it. I got three principles I think we need to consider. And one of them is, what are the commissioner responsibilities? What are those real true responsibilities? And what I believe, and I'll explain why I believe that, is that it's about policy, advocating for programs and funding for programs that help us in the long-term stability of the county, managing the budget, economic and community development. And we should not be managing the daily operations in the county staff. In our position, that should not be, that's not what we should be doing. Two, implementing the government structure that's in the best interest of the staff and the county as a whole. That should be a principle. What is that structure? Three, under the current structure, the county judge has too much power. Period. That's my opinion. We're arguing about who should have that power right now today through personalities, not through principles. position clearly has too much power. I know I know what the three primary responsibilities of the three members of the local government should be. I'm gonna base, some of what I'm saying today on my experience for 3 years on the county court. I'm just about to end my 3rd year. And when I came into this, I didn't come in here because I had a personal vendetta against anybody. I didn't come in here because I hated anybody. I didn't come in here because I didn't believe in what they were doing. I came in here because I didn't think the county court as a whole was getting enough done. And I thought I could make a difference. And I believe I have made a difference in a lot of areas. Got here, there was no job description. Didn't have a clue. Just kind of jumped in and started trying to learn. When I was in Salem and talking to other commissioners, colleagues around the state, one of the analogies they use is like drinking out of a water hose. I soon discovered it wasn't like just drinking out of a water hose, like drinking out of a water hose and swimming in the mud puddle. It was just unbelievable. That 2-year learning curve is the damnedest thing I've ever been through in my life. And so what I did was start getting involved. And I learned from commissioners around the state what this work really is. I didn't learn it here. There wasn't anybody here teaching me. There wasn't anybody telling me. I went out and I spent time in meetings, moving around the state, getting involved in all kinds of things so I could learn, and I watched and I paid attention and I watched them testify. And we went to that first year, we went through the long session. Good God, I had no idea what a long session was. I had no idea what the lobbying process was with AOC. It was unbelievable. I found out there was about 5 committees that I needed to participate on, and I got time to really zero in on 3 of them. And I made those my priority. And then I attended legislative meetings. And the legislative committee, who makes the final decision to direct their lobbyists. And I learned what that was about and how that works. And we have 2 votes in Gilliam County on the legislative committee. And they're the 2 judges. And in the 3 years I've been there, there's been a certain amount of participation from Judge Farrar Campbell. She votes sometimes against what I would vote for, and I got to sit there and not be able to vote and watch her.
And usually abstain. I think you're.
And the other judge I've never seen at a meeting. Ever, in 3 years.
Because it's against my judicial code to get.
I don't know why, I don't know why we can't, I don't know why the county can't have at least 2 votes on that, in that structure. There were gun bills and things I thought we should weigh in on.
I can't vote on, I can't get involved in
Okay,
that.
I don't know that. I'm just telling you from my perception. Here we were, and we got 1 vote usually.
Yeah, I can't.
And I went to all those meetings. So what I did was I learned from men and women around the state of Oregon on how to do this job. Leanne Thompson from Clatsop County, Danelle Bethel from Marion County, Paul Anders from Union County, Todd Nash from Malawi County, Adair and DeBone and Chang from Deschutes County, and Kelly from Madras. I mean, Dan Doran and John Schaefer from Umatilla County. I didn't learn too much about Morrill County because they were in such transition. I didn't get a lot there. I learned nothing from anybody from Wheeler County because they don't participate. There isn't anybody in Wheeler County. There's very few people in Salem and in the other counties that even know who's on the court in Wheeler County. That's not where we want to be. I'm telling you, this is not a part-time job, and I haven't treated it that way. But I learned how to do it by going out and just doing it. And this year I've been effective. I've got to do some things and testify and do some things that are making a difference. And they make a difference for the state of Oregon and a difference from Gilliam County. I think some people may think, good Lord, what do we care about that? I've been working really hard on ballot measure 110 and how to fix it. We hauled a couple of people out with overdoses recently. It's here, it's coming. And we're gonna ignore it? And so I'll tell you what, David Yamamata from Tillamook County
Good guy.
and Les Perkins, well, David's retiring the first of the year in early retirement. Les Perkins is not gonna run again for Hood River County. Steve Kramer's not running again for Wasco County. Those are huge, huge losses to those counties and those communities. They are gonna suffer when those guys go away. It's gonna take a long time, or it's gonna take a while to replace what they bring to the table in the state of Oregon and for their communities. I've had some really amazing conversations with legislators, the governor, representatives from the largest company in the world, meeting regularly with one of the largest companies in the world right now. The really cool thing is I've got to know them and they know where Gilliam County is. And we're the largest producer of wind and solar in the state of Oregon, and that packs weight. We're in a situation in Oregon where decarbonization goals are a priority from everybody on the other side of the mountain. And we're in a place doing things that they're amazed this little community is doing. So I'm just really proud of the body of work that we do. But the bad part about what happens here is, and I'm not sure how we get to a place where we eat our own. And that's what I feel like we're doing. We're just absolutely eating our own. And it's from nasty politics and the place we're in and personality, popularity contests and all this stuff that we shouldn't be in. And so I'm in favor of going to a board of commissions for a reason. It takes the county court, board of commissioners, whatever you want to call it, out of that management of the daily operations, out of managing the employees that get used as a tool to drive somebody else's agenda. And when I say that, that outside interference is what destroys morale that the county court gets blamed for. And it is BS that it even happens, but it's allowed because of the structure we have as a Gilliam County, as a court, a county court. It allows through the process of elections to take a guy like me to spend 2 years of my term trying to learn how to do the job, be effective 1 year. And then if I want to do it again, I got to fight like hell to do it next time around. I got to fight through that election. And absolutely what happens to the employees, because we've been through two major structural problem or structural management changes within the Gilliam County court system on how that management of the employees and the daily operations function, first through a chief of staff, not widely accepted and a little rattle around about it over the, for a while, but then into the most effective place I've ever been the last year and a half. With we got 3 outstanding employees, and the way this has worked is they're basically kind of doing what we're talking about a board of commissioners doing. They're doing the administration for the most part for the county. They're not net. We are managing. The 3 of us have split up the management of the employees, which is really the nasty part of the job we shouldn't be doing. I'm managing the road department, and that does not make any sense to me today. I don't need to manage the road department. We have a perfectly capable roadmaster. Now, he needs a little help. Him and I have lots of discussions. He needs a little help around compliance, procedures, and we've had those talks. He knows. He's working on it. But I don't need to manage what he does every day. I don't need to be in that loop. It's stupid. That's not where my time should be spent. And just in what Liz has tried to do is remove herself from that so she can do this other stuff. Not much recognition or pats on the back for it. We're too mad at her. We've got people that think she's the devil and Chris is the angel. We got people that think she does a pretty damn good job that have had trouble with Chris in the past. So it's all there, every bit of it. But we're caught in the middle of this mess that absolutely doesn't help us do the job that I've learned to do. And it's not the work that does the benefit to this county long-term, 50 years down the road, that's gonna make a difference. That's the stuff. And so I'm against anybody in local government managing employees or managing the daily operations. I think we have a play in that through the structure, and I think it should be 3 evenly paid at my wage, no increases. Commissioners, I actually think it should be 5, but that's another conversation. It can be 3 pretty rapidly. And what we've got going on today, and why this is crucial and critical and near a crisis, is we have what I would describe, after being around in a management position for 50 years, created this system has allowed us to create a hostile work environment. And
Kelly, could you mute yourself, please?
And I spent about 3 weeks ago in the courthouse, and I don't spend a lot of time in the courthouse, so I'm not around this all the time. But it's become pretty apparent what's going on for me. And I spent an hour and a half running from one end of the courthouse to the other end of the courthouse, passing information back and forth between employees. And I said, what in the hell is going on here? How come you people can't talk to yourselves? Why am I passing information back and forth? And so I said, we have 3 of the most talented administrative people I've worked with in 50 years. One of them resigned. She's done the end of the year. Another one looking for a job, and another one talking about looking for a job. That has absolutely neutered our ability to provide the services we're supposed to provide.
I really appreciate your answer. And so in your mind, the genesis of this, for the urgency, is the employment issue?
The urgency is we have, and it's the structure. I don't want to blame any individuals or anything else, but the structure of what we have.
I'm just asking for your opinion, sir. I truly appreciate everything that you do and that you promote. My basis of the question is simply put, what is your primary reason for the urgency of moving this forward at this time? And if I'm hearing you correctly, sir, that reasoning for you is the unstable employee relationship with the commission at this point.
Which has caused us to lose our support staff, which we have been extremely effective. A really tight working group of people that have got a lot of work done.
Okay, great.
And that's going away. And so how are we going to provide services for them? We still got, you can elect me or elect somebody else. You can elect Grant, whatever it is. And I'm not here in a year. I still have a job to do for another year. And I'm not going to have any support to get that done. How are we going to provide services with what's going on today? How are we going to accomplish the stuff we're supposed to accomplish and administer that stuff that we're required to do? I don't even know how we're going to do it.
Understood.
So that sense of urgency for me is and this is not a fast process, for God's sakes, hiring somebody and hiring the quality of a person we're talking about hiring. But we do have within our budget to pay for it. I hear a lot about how you're going to pay for an administrator. It's a high paying job.
Sure.
Got it.
Sure.
But we have an administrator's position or executive administrator to executive assistant to the county judge position opens up end of the year, end of the month, end of the year. That's a big chunk of it. We also have, in my mind, We haven't had this discussion, so I don't know what they think about it. But we also have the difference between what the judge's position is and what I make. That's a lot of money.
Understood.
That's a lot of money. That'll pay for what we need to go and where we need to get. Now crucial, hiring somebody that fits that, that's a crucial stage of this, and it's not gonna be, that's a process in itself. And, you know, who know, we've all hired people like, you know, you've hired a lot, you know how that goes. But it's something we need to do to move forward, to move this county. I talked to, Leanne Durfee, full disclosure, my sister. Worked for the county for 23 years. Well, she's 22 and a half. She's in her 23rd year when she retired. She worked for 3 different judges, and I don't know how many commissioners. A bunch over that period. And she has the most respect she can possibly have for all 3 of those judges. No question. She thinks we need to go to a board of commissioners.
Thank you.
One other thing I want to say before I quit is, I also talked to Gina Nickel, who's the executive director for AOC yesterday,
Association of Oregon Counties.
Association of Oregon Counties, who, when I talk about all the committee meetings, she's the executive director for that entity. And her recommendation is to move forward, do the right thing, Pat, and you'll be okay.
Appreciate it. Thank you.
So I don't have, it won't financially impact me either way. But I also know that the very first session we had at Eugene or Salem with County College was all on county government structure, ethics and stuff like that. And it was, I mean, that was the first time I even went, oh, they have all these different structures. I guess I probably assumed that most people operated on the county court like we do. So until I attended that class and saw the different ways, and just like they were saying earlier, it's not one size fits all. It's just how we navigate that to best fit our county, in my opinion. So, the other thing is, if we are gonna do it, this year would be the ideal, because we're in between elected officials and also, and I lost my thought.
So we've got an administrative
And
position open.
we would also have to, we have a little short period of when we would have to start talking about budget and figuring out how that would fit in the budget. I think, wherever Nathan is, if it's like, March, do the worksheets go out in February for the budget?
Well, I mean, you've got till June 30th, so.
Yeah, but those worksheets will come out, and working through the budget on that piece will take some doing too, so.
Sure, but what's your reason? What's your reason for pro or con for this particular?
My personal reason is,
Yeah, sure.
so I will tell you that when I talked to Pat, when I first got elected back in May, and he told me about the fire hose part, and I have to totally agree with him. It is like drinking out of a fire hose, not a little garden hose in the backyard. And it has been, first thing I got pushed into the deep end on was public health. So, and that was at that time a contentious thing, and it has been a nonstop. I have spent hours and hours and hours on the public health piece because I believe it's important for the county residents in Gilliam County, so.
So maybe.
And I got thrown into doing the transportation, so, and that has had some problems of late. We had a bunch of grant reports that were, had not been reported for a year and a half. We had a site review in the middle of that. We had 2 employees that departed. It's not been fun for me, I could tell you that. So the fact that maybe I could have an administrator or somebody like that that actually would do that job and take that off my plate so that
There's things I would like to work on. I would like to look at a park and rec district possibility that would help support schools and parks and libraries and all the other things. And I can't get past just doing county court agendas and my transportation and public health stuff, and on a part-time basis. So that's why it's attractive to me. So does that answer your question?
Kind of. Pat, did you want
There's a
to-
couple of things I wanted to say, and I don't know how all this process works. I'm just feeling my way through, like I said before. But it looks to me like if we could get to a board of commissioners right away and get moving down the road with hiring an administrator and getting that in play. This is my idea, okay? That we can move forward and start a charter review committee and really go back and look at how do we want this? Do we want it to be 3 or 5, and some of the more details to this? That process will take a year. And
And
we
the
don't-
5
we-
does have to go in front of voters.
And we don't have a year to kind of fix where we're at and make sure we can provide what we need for the next year. We don't have that year to do that. And the other thing I want to say is that this structure is not, it's not unusual for Gilliam County because we do it in every other entity.
Well, I understand that and can certainly appreciate it from the commissioner's point of view. The root cause, okay, let's really get down to the cause on why you feel that this is an appropriate thing to do at this time. And Commissioner Shannon has certainly expressed that it's relieving the stress of having to deal with employees. You, and I'm sorry, ma'am, I forgot.
Leah Watkins.
Leah.
That's
I'm
okay.
sorry. Has expressed basically the same reasoning behind why you want to do it. Again, employee-based. And I appreciate both those. I have more than a casual understanding of what it's like to run a lot of employees.
Todd, just to correct you from what you're saying about what I said, it's not about the stress around employees. It's about the focus you have to spend to run on employees that you miss what we really should be doing based on what I've learned from the commissioners around the state.
I appreciate the input. Thank you. And thank you. Ma'am.
Yeah, so I think would piggyback off of what the commissioners have said. I think I would add though, part of the reason we're structured the way that we currently are, where each of us are taking. First, let me say that under previous courts, there's been a long-standing road and weed commissioner. So there's always been one commissioner who has taken on, well, not always, but for a significant period of time. I think Commissioner Weimer was the road and weed commissioner. Leslie's been the road and weed commissioner at times. So that's a long sort of standing thing where there'd been a separate commissioner. It makes sense if you look at the budgets and the number of personnel. Dewey runs one of the largest budgets, has most of the personnel. So I just wanted to make sure that that's clear. One of the things that we, throughout the 5 years I've been on the court, is we've explored different ways of how we manage staff. And the staff has grown considerably since the days of Judge Pryor, for instance. We have a much larger public transportation department and a lot of other services that we've added. So all of this to say, we have tried different methods where we, and this was actually under Commissioner Wilkins, so it was before Leah joined the court, but Commissioner Shannon was there, collectively decided that it made sense for us each to take a portion of the county departments and supervise them. And I will explain a little bit why. When I first came into office and was managing staff under the way that had previously been done, if I made a personnel decision that other people in the building, other elected officials or other employees did not agree with, more times than not, and Leslie could probably speak to this, the commissioners would get a call asking them to overrule the decision that I was making as an administrator. That happened a number of times. And so we have explored different ways to share power amongst us. So we've tried a chief of staff that did not work particularly well, as Pat discussed. I think because there was still some questions about what my role was versus what her role was. And so this last iteration, we collectively, as the court, decided that each of us would take a number of departments. I supervise the majority of those departments, but Leah takes on a number of large ones, and so does Pat. And so I wanted to put that on the record, that was a court decision that we made based on some of the things that we saw early on, as far as the dynamics Pat was referencing within the courthouse that we're dealing with, trying to make this work for staff. What I see as potential key benefits, and again, I want to remind folks at the beginning of this conversation that I declared a potential conflict of interest. So I want to be a little bit careful. I'm not going to speak about compensation or what I think timing of things should be or any of that, because that draws me into an actual conflict of interest. But in a general sense, what I see is when I came in to the county court, it was actually a unique time because Leslie, I keep referencing her because she's in the back, but she had been appointed to fill Commissioner Blomquist's position. So she was in the situation where she was having to run every 2 years, basically, to fill his position. And it just so happened that that particular year, both Sherry and I came in as new people. And Leslie, I think, had been there, maybe 18 months, almost 2 years.
Yeah.
So speaking to the fire hose that they're talking about, those first 2 years are kind of, they're not, I wouldn't say they're lost years, but you're just kind of getting your bearings for how the job works and what the process is and what the laws are and what your responsibilities are. And so where I see there is a potential benefit is when you put the management of staff in a professional appointed position, that continuity continues regardless of who is sitting up here. And what we have found, and our insurance company would confirm this, that a lot of the most litigious things, the things we're most likely to get sued for as a county, have to do with our personnel. And making sure that we're following all of those myriad of labor laws appropriately. We do have a union, which has an entire additional layer of complexity that we obviously want to be a good employer and meet our contractual obligations. When you come in as a newbie and you're trying to figure out what public meeting laws are and ethics laws and all of those things, I think it puts the county at greater risk when you put management of staff for somebody who maybe the public elected because they're very effective project managers. They have really good ideas for what the community can do. That doesn't necessarily mean that they are managers. Those are two different skill sets. And so I guess what I would offer is that I think when you look at, what Pat sort of alluded to, when you look at our school districts, you look at our cities, just about every organization that we run locally, it would be akin to saying, every 4 years, we're going to vote publicly and select one of you in the room to be our superintendent of schools. Like, we wouldn't really think probably that's appropriate. Like, we elect a board to oversee that superintendent, but we expect the superintendents have expertise in managing people and understanding the administrative part of the school. I think what's being suggested here is a similar structure. To have somebody who can maintain that continuity of management of staff, making sure that we stay compliant with labor laws, that we are doing right by our union members, all of those things. And what that allows newcomers onto the Board of Commissioners to do is really focus on the things that actually impact all of your lives, right? Like,
And the lives of our employees.
yeah. But, I would say to be frank, a lot of my time is spent on interpreting policy that has been set here, comparing that with statutes to answer employees' questions about how does this impact my benefit? What is my hours that I need to take for leave here? And that's fine.
Stopping a mutiny over going to a time clock system.
Exactly. But the trade-off for that is when I am doing that, and I'm, that's the job I signed up for, so that's what I do. But if the choice is between doing that and figuring out how to build more housing, then, because that's also my job, right, is to figure those things. There's a trade-off there, and the employee naturally comes first because that's the most pressing, important thing on my plate at the time. And so what I have seen over time is, particularly if there's an issue with an employee that we're working through, especially if there's something related to a disciplinary action, something like that, it really sidelines our ability to actually move forward initiatives on the big county concerns that you come and talk to us about: fiber, childcare, economic development, housing development. All of those things, unfortunately, have to be put to the side when these other more pressing issues come up. If you have a county administrator, those things don't actually come to me or the commissioners, and that allows us to stay focused on the big picture things that the community cares about.
So just a very quick follow-up question,
Sure.
which has me a little bit baffled at this point. Why consider going to a 3-commissioner board when in fact the problem is identified as primarily management of employees? Why don't you just hire an administrator?
That's, well,
That's a pretty easy question.
Whoa, there's a flash.
there's some structure within it. So what is it that you want to do? At that part of that reasoning behind that for me, Todd, is how do you pay for that administrator? Because it is a high-paying job, and so we have a heavy impact to the budget for that long term.
You bet it is, Pat, but let's look at the budget side of this, for example. If you decrease her wage down to what their wages are, you've gained 50 grand, okay?
More than that.
Cost you,
Way more than that.
recount benefits, whatever. An administrator is gonna cost you somewhere between 130 and 190,000 a year, without batting an eye. Either direction that you go, whether you keep the county board as it stands, or you go to a commissioner side, you're still looking at $150,000 to $160,000. So it really doesn't matter. What does matter is the fact that as a county commission, okay, or commissioners and a judge, is simply this: the inability to be able to do your job because the focus is taken away by managing employees. That's the root cause of this, if I'm understanding everything that you're saying. That being said, look, we all understand that people get overwhelmed. That's fine. What's the solution though? The solution, by all 3 of you, is a county superintendent, manager, whatever, to deal with the employee problems. I'm really confused on why we need to change the county structure governmentally to achieve that goal, to relieve the pressure. Now, I understand there's a few little minor issues in there, like the county judge having a little too much power, maybe, things of that nature. I get that. But the interim problem, until this can be pushed out to the public a little bit clearer, the interim problem is get a darn administrator for this. That's not gonna go away no matter what you do.
Yeah, it's an impact to the budget. That's what I'd
It's
say.
gonna be an impact to the budget, but come on, crying out
No,
loud.
I'm not opposed to, I'm not.
Hold on, let Pat talk.
I'm not opposed to that if the community is not opposed to that, but what I get anytime we look at doing something like that is you're spending money you shouldn't be spending.
I understand that there needs to be some, selling of the project.
Oh, no kidding.
Okay, so it doesn't matter whether you're a corporation or whether you're a county, whatever. Anytime you want to increase your budget, it's always a hassle. I get that. On the other side of the coin, situations like we have here in this room right now is showing the ineffectual process that y'all are doing when it comes to your employees. It's so distracting and so taking away from what you could be doing then now we're into wanting to change the county governmental process? Come on.
Well,
And I'll just leave it at that.
okay, what I would add to that is in my discussion with Jeannie yesterday is that, the home rule situation was really designed for rural counties in the 1960s or whenever it was. And it's really antiquated. And everybody needs to move into the 20th century, and the sooner you can move your county into the 20th century, you're better off you're gonna be. And that's her opinion, who works with all 36 counties, which is in controversy to those that say, you've seen one Oregon County, you've seen them all. You know, what is it we're trying to preserve? What are we really trying to preserve by staying where we are instead of what seems to be a very efficient system elsewhere?
Okay, can I make a comment back to you on that? While I appreciate the history and the plodding along of a commissioner judge type of government, I do think that 3 commissioners, 5 commissioners actually would be a much more equitable situation for the county as far as representation to the state goes. I get that, and I can appreciate that. What we've got today, though, is wanting to change the current form of how we run our government in Gilliam County to take care of a problem that is actually the root cause. So let's take care of the root cause first, and then, you know, because I would support a multi-commissioner role, knowing full well what it takes to do that in today's world. That being said, no matter how you look at the budget, you're gonna buy an administrator. No matter what you do.
Yeah, but we have the funding in the budget today is my point.
What I'm saying is that no matter what you do, you're gonna buy an administrator to take that off your plate to deal with it.
Can I just ask a clarifying question for you under the scenario where the administration is handled by an appointed person, what we're talking about? In that scenario, would you envision that the county judge's job also become part-time?
Correct. It would become just a commissioner situation, because quite frankly, that's taking, I would venture a guess, is somewhere about 80% of your babysitting duties.
It would be a significant amount of my time for sure.
Yeah. So
yeah, I just wanted to clarify that point because to the point about funding, that there is a significant difference, obviously in compensation to the tune of about over $70,000, I think.
So you would have to do the ethical thing with the integrity of ethics to, if you hire an administrator to do those things that you were elected to do, take a cut in wages. That's just the way of the world.
Right. And to be clear, as I just said, if it does impact me financially, I, by state law, have to bow out, but I just say in a general term, I think the commissioner should do what they think is right and not worry about my compensation. I'm gonna go to people who have not spoken yet. If you have already talked, put your hand down. Let's go over to April and then we'll go to Leslie, if that's all right.
April Ahmed, 1175 West 2nd Street in Arlington. Okay, so Pat, you brought up, you said we get 2 votes because there's 2 judges in our county. So if we went to a commissioner model, would we get more votes?
No, that's a whole different, I was strictly speaking about the process through AOC and the legislative committee that currently has 2 Gilliam County residents that get to vote on that committee. And that committee directs Association of Oregon Counties how to lobby with our legislators for the needs that come back to the communities in Oregon. And so when we don't have our 2 votes, it's like, are we losing some weight on what we're trying to pull back to Gilliam County? It's a Gilliam County issue.
To clarify on that particular thing, Judge Patnode is currently has a vote, but I just wanna clarify, that vote is not Gilliam County's seat, it's
Right.
because of her leadership role within the justices of the peace. So
I mean,
wanted to clarify
I
that.
was just wondering if it was a benefit, like if you were listing pros and cons. So I'm wanting to know if that
No.
would be a pro,
No,
because we would get more votes somewhere, that's what I'm asking.
No, that vote
By
is,
having three commissioners.
that
no,
vote
it's
is,
just the concept that, when you're deciding what to vote on, no matter what your entity you're serving under, where you live would weigh into that vote.
So, okay, so when, Todd was speaking, I mean, it's always beneficial to have somebody come in with ideas rather than just complain what you're doing, right? We've all sat on boards,
Absolutely.
right? So, I know the end goal, and I've heard you guys speak about 5 commissioners. Is there a reason that we can't go with a judge and 4 commissioners?
yes, I, to
Can
my,
you legally not do that?
to my understanding, let me double check that with council, actually.
Okay,
My initial understanding was that you needed to be a board of commissioners to actually be able to change those numbers. But it may be that, through a charter process, that there may be a way through
It
the
may
charter
could-
process
it
of
could
being able to do that, but I don't know that for sure. I
Because
would need to
what-
ask legal counsel on that.
the way I'm listening to what Todd is saying is that, and you were saying before, is you would elect a chair, possibly the chairperson of the commissioners, right? So that wouldn't be much different from what we have as a judge right now. Hang on just a second. You could still, I'm going back to the juvenile part because I'm an employee. I do believe that, I don't think that juvenile court, I don't think it's been a bad decision to remand the juvenile court to circuit court in the last 5 years. It's actually been pretty smooth. And I know I appreciate the judges that are there. I do have a question on the legality of the probate. And so that's why I'm thinking this, really, we wouldn't have to make that much of a change to get to take care of the problem. We would have to come up with money, right? And then the other question I have is, we don't have people knocking down the doors to run for commissioner or run for judge in our county. And so I'm wondering, is it gonna be a difficult problem, getting 5 qualified people to run? And no offense against you guys, but you weren't qualified. I mean, you're saying it right now.
Yeah.
You were in it 2 years before you got a handle on things. And that's kind of like, if I run in 7 years when I retire, I'm gonna be in the same situation.
Mm-hmm.
So I think those are maybe things that could go on your list
Mm-hmm.
to think about, because I can hear everybody's concern, and I wasn't really against the 3 commissioner model. But then last night I was listening to everyone's concerns at the listening session that Kara had, and I thought, what would be the difference? If we have a chair for a commissioner, what would be the difference in keeping our judge and having our judge? Because of the power that they
Well,
might
I-
have?
The,
Because it's really, it's really no different than the commissioner, if they're only a part-time, the chair.
basically, we even today have equal power. That's really, but, couple of things on that is.
Yeah.
Oh,
My phone is, with the Board of Commissioners, and when you start looking at the chair position, this is my opinion, okay? That chair position should probably be decided by that board. And you would automatically probably put the person in that position, if you vote on it annually or whatever, it'd probably be an annual vote, I don't know, I mean, those things look at, that had the most experience on the board. That had the most institutional knowledge about what's been going on. When you elect somebody into that, like a judge, all of a sudden you have brought that person into that board who has 0 institutional knowledge. to run the board, which is in fact, some power. You know, and it isn't by vote, but there's some power and influence there. And then one other thing that was said about maintaining the judge's title in Salem, I think Laura Pryor, probably Steve would tell you that's really, really important to have that title in Salem. My experience has been that's not what's important in Salem. What's important in Salem is to be in Salem and talking to people, no matter who you are or what your title is. It doesn't,
Wholeheartedly agree with that.
it doesn't have anything, it's about the work you put in to do that, not about the title. That the title's not gonna open any more doors. She has no advantage to get any more doors open in Salem than I do. Period. I promise you. So that argument falls on dead ears with me. But I'm just saying when you start talking about the Board of Commissioners, how you select that chair probably plays into my decision.
April, did you have anything more? Did you get those covered?
I just that, I guess what I'm looking at is, I think that I'm kind of a mediator, obviously, everybody knows that. So I think there might be a happy medium in the fact that we go to a judge that's paid part-time, we have an administrator, which is like a superintendent of schools. And we could possibly up it to one judge, 4 commissioner board, and be able to keep the power that we feel that the community feels, and our community, Gilliam County, feels that we have in having the structure that we have. Plus, we don't really know what probate is. I mean, you know, it's one attorney's idea against the other one that kind of represents us. So I think we need to look at that a little bit more. And our elected officials, I think have felt like they haven't had quite a say in our, in everything that's happened. And so I'm being the mediator. I just feel that with a superintendent, it might give them a feeling of ownership, because right now we're so parted, and being an employee of the county is almost a little bit embarrassing sometimes because everybody's in such an uproar. And I'm not proud of that. You know, I don't want to be that way. I love when everybody gets along. And so, but I feel that our elected officials could use maybe some management, you know, because some people are elected and never have management training. But that superintendent could do that for them. And then it leaves the, you guys in Salem where you need to be lobbying for the rest of us. That's my feeling. So that's all I had to say.
So it sounds like some of the takeaways there are exploring whether there's a possibility of doing 5 under a county court structure. I don't have a good answer on that. I made an assumption, but I don't, there may be an option through charter. I'm not sure if there's an ability to do it otherwise. So we'll look into that. Leslie, do you want to come up here?
Hi.
Hello.
I'm Leslie Weatherall, 775 Main Street, Arlington. I need to make a comment because I think my blood sugar's getting low. I think I need to go get some food. I can't go very much longer.
April's got candy.
Yeah,
and
I had
popcorn in the
cookies,
back.
but that was hours ago. First off, I just want to thank you all for being on the county court, serving your communities. I know it can be difficult at times to make the best decision you can with the information at hand. So thank you. Sitting here listening today, I've had a few thoughts on the topic of changing our county court structure. If it is found to be lawful to do so, my thought today is that it possibly could be a good decision. I don't know. I haven't had that much time to think about it. Maybe it's a decision our communities would embrace, but we should let everyone decide. There is an expectation of the people that the commissioners they elect will be their voice and listen to them, especially when so many feel so strongly about an issue. I personally think some decisions are too big for 3 local people to make for our county and should go to a vote of our people. That's the way I felt when I was on the county court, and that's the way I feel now. Even if, as commissioners, we are provided compelling arguments for making a change, ultimately, decisions of this magnitude should be up to the people we represent. So the only thing I have is just one question after hearing what everybody's been talking about. If it is found to be lawful to abolish the judge position and go to a board of county commissioners, will the county court make the decision or the voters?
So that would be up to the court would have to decide.
And
So,
which,
Memo, I don't think we're there yet.
any thoughts on, I mean, we just don't know yet.
I'm open-minded here, yeah.
And I do know that the 5 has to go to the voters
Right.
regardless.
Regardless,
So-
that has to go to the voters. And that's why I offer up the interim. Move to 3 and then go through that process to see where we want to end up down the road.
So if we do move to 3, would that be something that you think the county court's gonna decide, or?
I think it's something the county court can decide based on precedents and been done before.
Oh, yeah, no, I know they can decide, I just was wondering if you
I
thought
don't know
that
that
was.
we're there. I don't know that we're into that discussion that far. We're gonna go there today. I'm not gonna make that motion today.
And we're gonna have a meeting in Condon and for that discussion too, so. And then if there needs to be another meeting after that, then we'll have another meeting, so.
Well, Liz said several.
Yeah, I would.
Year and 1 year.
Yeah, I think if
Well-
you're actually looking at changing title by filing, there is a sense of urgency in that too, granted, it's not before the filing started, but it's damn sure before the filing ends, which gives you the opportunity. A lot of filings in my experience have happened in the last week, sometimes the last day. So, I filed early this year and I didn't know you could file that early. But,
You're talking March 12th.
yeah, which is coming. I'm just saying there's some timelines within that if you were gonna move forward that I really think should be considered in the fairness to Chris and the fairness to anybody else that might be interested. I think there's probably some consideration where people wouldn't apply for a county judge position, but if it was more of a, I'm gonna call it a part-time position, it is by FTE. That's not how I view it, but if you had some people, I think it's real important that when you look at this as voters, what you really should be focused on, in my opinion, is who's gonna be on that board or who is now most of the focus in the past has been on who's the judge. It really hasn't been even on who's on the elected officials. The focus is always all around that judge's race. And the community really ought to focus on what those commissioners bring to the table. How hard they're willing to work, what they're willing to do, because you're gonna get commissioners that think it's a great idea to be a county commissioner, because I only gotta go to 2 meetings a month, that's all I gotta do. And is that what you want? You get to decide.
Thanks, Leslie. Other public comment? Do you want to come up again?
Grant Wilkins, Arlington.
Just talk loud, maybe,
Yeah,
see if
I'll
the.
You got a good voice.
Kind of forgot what I was gonna say. I know we need to get to the end of this, but I want to make sure I understand this. So if we go to a board of county commissioners, that can be decided by the current court, or it can go to the vote of the people. Correct?
Under statute, yes.
But the action you took on the 6th of December with the juvenile and probate is court decision only, not to the voters?
The statute, yeah, the statute is really clear that the county court is the only entity that can give up that jurisdiction.
Okay. I just think the way that happened has snowballed a lot of people getting. That's a big decision. Both of these are big decisions. And I think it was done too quick. It's been talked about, but it was put on the agenda and then possible action, and you guys took action, which I don't agree. I think there should have been, it's like Pat said, there's 1,400, the voters need to be informed, and I think they should have the choice of doing this. And especially with this Board of Commissioners, I don't think that should be made by 3 people. I think that should go to the voters. And it sounds like trying to get to that is there's some problems with the, I guess, management or employees. I'm trying to understand, I don't know why, I mean, I've lived here most of my life, and I don't remember hearing this much of a problem with some of the stuff that's been going on before with different.
Oh, so I'll go back to, I worked at the courthouse when I was 22. And at that time, it was the upstairs in the courthouse against the downstairs in the courthouse. So this has been a 40, 50-year-old going on in the courthouse.
Okay, and I know there's been some big projects come into our county and stuff, and like the 90s when Waste Management came in, that was a big change. And I don't know, I was a lot of meetings, and I you know, there was a lot of emotions and things like that, but I don't know, it sounds like there's a lot of fires going on. And the election's only 4.5 months, a little over 4.5 months. He's talking about the budget's coming up. I don't know, I just think that this is not the time to do this. And I don't know, it's important to get the information out to the people. Like I said, he's saying, spoke on some things. Communication, I don't care what you do or what you say, it seems like we all fail at it. And with what happened on the 6th, with transferring that, I don't know, people wanna know what's going on, and is this the right thing? What's the pros and cons? And, you know, just like this is a big decision. And there needs to be some, it was nice carrot coming down last night, you know? The problem is too, is people work, they can't get away to come and participate like today. You know, and I don't know, I think that's why it's important to have some extra work sessions. Meet when people aren't working and make it available, and I don't know, Leslie, my last question, I guess Leslie, this is the same thing Leslie is. Does this board think that they should make the decision, and you guys kind of not really saying, but I don't know, personally, I think this definitely needs to go to the voters. Thank you.
Joe, go ahead.
Just really quick, so a 3-person commission can be voted by the current commissioner, by the current court. But if you were to ask for a 5-person, that has to go to voters. So why not just go ahead and ask for 5, and that just goes straight to the voters. And instead of trying to take this all on your own, I mean, ask for 5 and put it to vote.
That is one more question we would have to look into. I'm not sure if we could actually do that. And the reason I say that is that some of the law regarding initiatives say that you can't ask 2 questions at once on a vote. So you can't ask.
So you can't, if you had it already has to be a commission board.
I need to confirm that, but because it's, you're basically asking 2 questions. Shall the county court convert into a board of county commissioners, and should it be 5? Whether that would have to be 2 separate ballot measures, and if so, it's problematic because if the public voted for 5 but didn't vote for the Board of Commissioners, I'm not sure that would be legal. So, but we'll ask the question. I'm happy to ask. That is my assumption from what I have read on initiatives, but we have not asked legal counsel to answer that specific thing. So I'm happy to ask for feedback.
And Joe, to answer your question about why now, because I tried to explain, and if you didn't quite understand, I feel a sense of urgency based on a lot of what I said.
Oh, I get you, and then the decision could also be made in the 5 months from now, or when, you know, and so that's pretty urgent.
Well, the urgency for me is the daily operations, how do you keep them going?
Okay, so before I get to you 2, I want to make sure that there's no one else who hasn't had their first chance to speak that would like to weigh in. Joe.
I'm
Joe, Can you come up, please?
Joe
So-
Patno, Mike Lowe. Trying to understand the urgency when your courthouse is gonna be closed until April.
Services don't stop.
Well, so everybody works from home.
Service,
So I'm wondering the employee part. A lot of people are home or not working out there, so what is the employee part that's such a big deal if we're not gonna be there?
Employees
My
are,
question.
I was gonna say, employees are still being managed, and actually the vast majority of the employees are still in the building. There's a small subsection that have been displaced, but we're talking about 2, maybe 3 people, so. Okay, Dana, we'll come back to, wait, hold on one more second. I just want to make sure nobody else who has not had a chance to speak for the first time. Now we'll go to Dana.
Okay, in the face of 111.075, which says that the county judge is vested in this county, how are you still considering going to a commission? Doesn't 111.075 put a stop to that right now? Because even the attorney said, did I misunderstand her?
No.
Didn't she say that that puts a stop to this?
No,
Did I misunderstand something?
that is her,
that's her opinion.
that is her
That
opinion.
it was not legal to change to a 3-commission panel.
And we have legal counsel
That is
that has
her
the opinion that it is.
What legal counsel?
Of course she's,
All
yes,
legal
of course our
counsel
legal
paid.
counsel is paid for.
That's why you hire him.
Okay, what legal counsel?
Our legal counsel.
Okay, and that is?
We have legal counsel out of local government law group.
And that is?
Her name is Lori.
Lori?
Yes.
Is Lori going to put this in writing? Because when I was up there, I asked you to get it in writing. And that we needed a name, a title, an address, and a phone number. Are you telling me that we're not entitled to that?
Dana, we have shared that this was reviewed by legal counsel. We have attorney-client privilege for her advice, but her advice was that we can proceed.
This is public information. This is public information, you guys. And what you're saying is, oh, we have legal counsel, but it's a secret.
It's not a secret. What I have said to
Then
you,
where is the documentation on that?
the documentation was the court order, which was signed off by legal counsel, which the county court approved.
And where is the copy of that court order?
Was part of the county court packet
Yeah,
on December 6th. So there is
I didn't see any such thing in my packet. I
Yeah.
had copies of December 6th.
yes,
Yes.
you did. You actually held it up during the December 6th meeting. It's not an ordinance, it's a court order.
No, I understand. But I was, oh, thank you.
But this isn't a signed copy.
Oh,
but it
gotcha.
shows Elizabeth and Miranda on it.
Yeah, this one that shows, oh, I gotcha. No, this doesn't say anything. This doesn't say that you can ignore that. It
By-
says pursue women
Dana, by inference, when I send
by
some,
inference.
would you please not interrupt me?
Would you please not interrupt me?
I'm actually a member of the county court, so I would like to be able to explain and answer your questions. If you're interested in hearing a reaction or response to your question, I need you to allow me to actually do that. So your question was the documentation regarding our legal counsel. And what I am telling you is that when I went to our legal counsel and said, I would like to put this on the court's agenda at the recommendation of our juvenile director, I need you to draft an order and ensure that you have checked all of the statutes to make sure that we are able to proceed in the transfer.
This document isn't signed by an attorney.
It wouldn't be signed by an attorney. An attorney does not have the legal authority to approve a court order. Only the 3 of us, as the elected members of the county court, can approve and sign it.
Okay, so this information is coming from a secret person.
It's not a secret person.
You don't know where it came from? You don't know where it came from? Am I the only one who doesn't know where this came from?
It came
You know
from,
where this came from?
So
It came from our legal counsel.
Who the legal counsel is, that they do not have to.
Okay, and what it says is pursuant to ORS 111.115, probate matters may be transferred at any time from a county court to the circuit court of the county by order of the county. That's by order of the county judge. That's what's in the statute.
The statute does not say county judge, it says county court.
Oh, and they say county court.
Proceedings.
By county court order. Right, but that's done by a judge, not by a commissioner. Right?
No. The county court, there are two distinct things we're talking about. There's the county court, us collectively as the governing body. And so yes, and so sometimes when you read statute and it says an order by the county court, it means the three of us collectively can have orders. So like, for instance, when you look at the Board of Commissioners statute, it says that we can, by order of the county court, abolish the county judge position and move into a Board of Commissioners. That is,
It says by ordinance, not by.
it does not say by ordinance, it says by order. Second is the actual court orders when you are a sitting presiding judge. Those are separate. What is confusing is they both say orders of the court, but one is, and if you read the top of the order that you have in your hand, it says the governing body of Gilliam County, which is the three of us. That is separate from when I am sitting in a judicial role as the presiding judge over the county court hearing a judicial matter. Those are two distinct things.
Okay, and you're telling me that I can't get a copy of an explanation from an attorney on why this is here?
You have the document
No,
that
it doesn't explain why it's here. It just says it's here.
the legal counsel drafted that and reviewed it
Okay.
with applicable statute to make sure that it is compliant with her interpretation of Oregon statute.
There is no legal counsel.
Again, she does not have legal authority to actually approve the document. Only the county court, sitting as a governing body, can actually approve the court order. So it would not have her name on it. She would not be signing it. That's not how
Okay, but
any of these documents work.
she gives you the opinion that creates this document.
Correct.
Okay, but we're not.
Document.
She created the document.
Created the document.
Be like a divorce attorney, he wouldn't sign your
Right.
divorce.
Well, yeah, no.
She wants to see the.
I want to see the opinion now.
That is
Are
the
you telling
opinion.
me
You
so?
have it in your hands. When I asked her,
Okay, this is the result of the opinion, okay?
correct.
Where is what she wrote to you to say that this overrode
She,
understanding of .075?
the fact that she drafted that and sent it to me and did not say to me in return, you can't do this under statute. Like the fact that she drafted it,
Yeah.
reviewed it compared to statute and said, it's okay for the court to consider this. By inference, I did not ask her to give me a written legal document opinion. What I asked her to do was make sure that we are able to do that and via the order. And so she drafted that, and that was before the court on December 6th. And that is the court order that you have in your hand.
Okay, you know what? I understand in a divorce that the attorney is not gonna sign my divorce. But he has documentation behind him. There's no documentation behind this, is what you're telling me. Okay, does that make sense to y'all?
I mean, what
What
exactly are you looking for?
Is it okay to y'all? Am I the only one?
No, we want to see documentation.
Okay, we're moving on. Let's go over here.
Okay, no, I have one more question. You took an hour, I can take a few more minutes. Okay, because I have one more question. Okay, you still haven't satisfied me on the answer for this.
Let's move
But
on.
I hear somebody talking about hiring an administrator. Okay, and you guys keep talking about funding. Okay? You hired a financial director. You found money for that. Okay? You spent $25,500 to implement a new accounting structure. You found money for that. And you implemented, did I say implemented? I meant implemented. you implemented the new accounting structure for $25,500, you found money for that. And you implemented payroll for $13,613, you found money for that. And you're paying $18,000 a year to outsource payroll for 50 people. You found money for that.
So
So why can't you find money for an administrator? Did you spend it all here on accounting and payroll?
I am pretty clear that we have said multiple times that there's money to do that because the executive assistant to the county judge position will be vacant as of January 1. And if there's a significant reduction in the county judge pay, there's enough savings in there to more than cover the county administrator. I think we've covered that ground now ad nauseam.
And I would add, would add to that, when you talk about hiring a financial director, that I was calculating, no public meeting over this was my thought, that part of the deputy clerk wages, deputy clerk assistant wages would go towards that. We didn't, the public weighed in on that and wanted a full-time position, which we honored. And we okayed that based on what you all wanted.
For deputy clerk.
For deputy clerk.
Yes.
That was the funding that was supposed to help pay for the financial director. So when you want that money, you have to accept the fact that how we were planning to pay for the financial director got taken away.
Right.
You have to say that's okay.
Okay, we are, hold on, we are moving on.
I would just love to be able to figure out a way to close this out if we could.
I-
It's been a long day.
Amen.
Sitting
Here,
in your position.
so here's what we are gonna do. We are meeting, and this will be on the next court agenda. So if you have a public comment, you did not get to hold on to it, you can either come to the next meeting or you are welcome to send us an email, call any of us individually. All of us have our cell phone numbers online. So we're gonna do that, but we do need to, at this point, move on. Thank you for what I think started, it's like a good 3.5 hour discussion. So thank you for that. We're gonna move into the rest of the agenda, which is basically announcements and the next meeting. You're welcome obviously to stay, but we're gonna close public comment on this for now and move on. Thank you so much.
So can I say something before everybody leaves? To me, the most important part of the meeting is the announcement at the end of the meeting, because you find out what your commissioners and your court are doing and what they're going to do. And everybody gets out and walks out and misses the most important part of the meeting.
Well, I would just like to be assured for next meeting that it is still a discussion item, not an action item.
There-
You had promised there would be several meetings.
There's no way for me to
Yeah,
bring
can't-
anything of action because the court
Yeah.
did not indicate if they're going in a direction and what the details of that would be. So I can safely say I don't have enough direction to even produce a draft because we did not get into those details, obviously. So I think you'll see a similarity. There may, maybe perhaps, a pathway might take shape, but there would not be any legal document to approve.
An idea to give a written legal opinion, perhaps from the attorney general, on the probate. Just because I'm thinking about people's estates. If there's no jurisdiction, there's an impact to their estate.
I
And think
agree.
about people
We
other than
have to
me.
resolve the question that the cloud that's looming brought to our attention most specifically by our district attorney, that questions, can we or can we not? Do we or do we not? You have to lift that cloud before you can really consider any further action, even any further discussion. Because even though other counties have done it, and it hasn't raised a ruckus, if we do it, it's going to raise a ruckus if it isn't stamped as signed, sealed, and delivered.
You know what, and you can't just say an attorney told me.
Dana, we're moving on from that. I'm closing public opinion or closing down public comments for now. We've got people who would like to move on with their day. So we are going into announcements and next meeting. The next meeting will be held in Condon. This one will be on January 6th. It is going to be in an alternative location. So I think we are having it at the fire hall for a number of reasons. One, to Joe's point, the courthouse is under construction, so there's gonna be a lot of noise in the building that day.
January 3rd, right?
In the daytime?
Is it January?
Let me
Yeah,
double check.
The first Wednesday.
First Wednesday, sorry, yep, that's January 3rd.
January 3rd.
It is currently scheduled for 10 a.m. We do have regular business we need to conduct. If the court would like to hold other sessions, we will announce those. But for now, we're keeping our regular scheduled time. I believe it will be at the fire park for a couple of reasons, but in addition to us being displaced from the courthouse, I think we're also going to go see the new ambulance that was purchased with county funds. So, Pat, what do you have going on?
Since the last meeting, I had a career board meeting. Also, I met with Jessica from McKed to start through the process of getting Gilliam County into the McKed strategic plan, which there'll be a meeting here in this building in January as we move through that process with EDA and what they're requiring. We had a road committee meeting.
So that's getting closer.
It's
from
getting
the kid.
closer, but it's still, we're still being directed by the federal government, how the process has got to work, and they're making some requests. The McKed is having to do some extra work on, and I'm trying to help them get through that work so we need to be incorporated into their strategic plan, and that's the phase we're at right now. And I encourage everybody with ideas of how that they could put in that plan or ideas about that plan to participate in that meeting, because it's really about what can McKed do for Gilliam County.
Jet, what do you got?
My help, she's scheduled January 17th,
I couldn't remember the day, yeah.
9 a.m.
9 a.m. in the morning upstairs or down here?
Yes, upstairs. I can't remember. I think it's upstairs.
We had a road committee meeting on the 14th, and I attended the on Zoom LGAC Local Government Advisory Board meeting on that following Friday. Went to Salem on Sunday and Monday. I testified or gave a presentation to the Health and Human Services Summit meeting on peer services, which if you want to know what that is, you can talk to me later. It's complicated. And that's where we're at. Then we got to today, and I'm tired. It's been a long week so far. Thanks.
Leah, what are you working on?
So, I just want to make sure that people do know that the county staff is still working. They can be reached on their phone numbers that is listed on that. So when people go into the courthouse and they get told that the county court staff is not working, that's not necessarily true. They can actually be reached on their phones, even though they are having to remote work because their area is being directly affected by the construction. I also attended a meeting that Pat was talking about as part of the CAC committee and talking about the possible relocation of the Cedar Springs Road to get around the railroad issue out there. Dewey's laughing. Tomorrow, Pat and I, we had the public notice this, but Pat and I are helping at the mill site in Condon, so.
It's gonna be interesting because I have a Norcor executive board meeting going on, and we had an incident at Norcor and lost an inmate. It's gonna be in that discussion, so
Well, you can do dishes.
I've got to be on a meeting and serve seniors.
And then the last thing I had is the dispatcher in the transportation department, Eileen Lori, started on Monday. So she's on board and diving right in there. So everything with the transportation department is starting to run a little more smoothly. So anyway, that's pretty much it. And Merry Christmas to everybody. And
So on my end, I wanted to let folks know that the contractors are moving into the courthouse. There is going to be an asbestos abatement portion that is occurring. I think next week, we are still waiting for the asbestos subcontractor to confirm why that is significant for the rest of the public. They have asked me to close the courthouse to the public for those couple of days where they're doing asbestos. It is not dangerous to staff. They just do not want to have to work around people coming in and out, and they don't want the public to be unnecessarily scared by people in, you know, their little protective gear. And so it will be by appointment only. I think most of the staff, a lot of them are using their vacation time around the holidays anyway, so it's always a good time if you need services, the week between Christmas and New Year's, to make sure you give folks a call and make sure they're gonna be in on the days that you're coming in, so you don't make a trip for nothing. But staff will make themselves available by appointment, not dissimilar from when we were in the middle of COVID. So I just wanted to flag that for people that folks are still working in the courthouse, but the contractor has asked us to limit some access so that they can move more swiftly and get that portion taken care of as soon as possible. Commissioners, I have a couple of things that I need actual direction on. They're not votes, but I need to know what to bring back to you guys. One has to do with, we received an inquiry regarding possibly leasing the wheat lab. I think I can say that it's our mills that's interested in actually doing that. Seriously, which would fall, I think it already fits with our EDA grant. But we have never leased it. So they asked what we would want to charge for it, and I didn't know what to tell them. I asked them to suggest what they thought was reasonable. And so what they came back with was $1,000 a month plus covering all of the utilities in the building. I wanted to see if that number sounds right, if you want a different
That
number.
number is extremely low, but I would go for it to get something to happen.
I think it would be nice to have somebody utilizing.
Huh?
The port only paid $1.
Yeah.
I would be encouraged to have something happen and generate something, get somebody in there so the building doesn't melt around itself.
Okay. So if you guys are in consensus, I will go back to Nan and we'll actually have legal counsel drop a lease, but I wanted to make sure I wasn't totally out of the ballpark. Is that
And then
okay?
the lease will come back to the court.
The lease would definitely come back. I just needed direction on it.
How long in term of lease? Because,
She does not say in here, but I can go back. Do you have any concerns about me?
I guess my only concern would be if another opportunity came along that was more beneficial to the county, but I don't know. Once you start a lease, you start a lease.
Mhm.
You are.
And I
I
think
would say I probably wouldn't want to run the lease any longer than at this point, than what we are required to meet the grant requirements.
Under the EDA,
Under the-
so the expiration of the
And
EDA.
then we
grant.
can look at it again on what to do after that.
Okay,
And so when does that come to an end?
It's a couple of years out.
good question. Delaney, are you still on?
Yes, I'm here.
Do you, off the top of your head, remember the EDA grant for the Grain Lab and when it expires?
I believe it is sometime in 2025, but I will have to double check on the exact date, but I believe it's 2025.
It's about a year and a half probably of a potential lease. Okay.
A couple of years at the
We will
most.
confirm that and get something drafted from legal counsel to bring back. Okay, so that is item number 1. Item number 2, we received a letter from Mr. Hegwood, who has had an agreement with us to use water at Shetler Station. When Miranda dug back in, it appears that it actually sunsetted, but he came back to us and has asked if we would be willing to re-up that lease for 5 years at the current rates. And so I need some direction on you guys. One, is there appetite to re-up it? Do you want to see what those rates are and see if there needs to be an adjustment? And if so, what term should I be telling legal counsel?
What is he using the water for?
So he is supporting a lot of the energy projects when
Yeah,
they
but
come
what,
in.
what are they doing now?
I don't know that he has any pending projects. I think it's tying up the water. system.
Oregon Solar's getting close.
Yeah, Oregon Solar will be coming in eventually. So I just needed to know, we need to know how to respond to him if you guys are open to
I just need more.
re-upping the agreement.
I'd like to see some more information about what we're getting for it and why 5 years?
Okay.
I mean, it's kind of a project by project need.
Yeah, and to your point about the,
So how much do they make a year off that lease?
it is, I think it's based on actual usage.
How are we tracking the gallons?
So there's a meter. It looks like, this is just from his letter. I'd have to actually look at that actual lease. I think it's about $1.50 per 1,000 gallons is what he says in his letter. How about this? We'll bring back the lease that just expired. And, because I mean, one of the potential issues is if we had somebody who was interested in actually investing in Shetler Station and needed substantial water, there may be some issues on whether we could meet those needs if we've already signed away or guaranteed a portion to other people. So it's just something to consider. There's nothing in the pipeline that I know of that would have huge water usage. But a long-term lease could potentially impact that if there's somebody who's wanting to invest and needs significant water. Okay, so how about this? I will bring that back on a future agenda with the old lease so that you can see it, and then maybe you guys can give me direction on how you would, whether you want to extend it and how you would like it to be amended, if so. That would sound right?
I'd be curious too, like what does this city of Arlington sell their bulk water for and what does Condon? So, and is it comparable?
Okay, so we'll do a little bit more research and bring it back. I don't know if we'll be able to bring it back December or January 3rd, so maybe the second meeting. Okay. Let me see what else is on my actual calendar. So, I would say, the only other thing is AOC is about to start ramping up again for the short session. And legislative days will happen in early January. I am planning on going down with my hat from the Early Learning Council. For those who are not familiar, I sit on the Early Learning Council, which is the governing body that establishes rules for childcare centers in the state of Oregon. So I will likely be going down and meeting with legislators about some stuff that actually impacts providers here in Gilliam County.
Sounds like their first priority is gonna be housing and second priority is gonna be fixing ballot measure 110.
Yeah, well, I'm hoping I can squeeze in some funding for employment-related daycare subsidies, so we'll try that. I think those are the big things, that we have going on and that I needed direction from. So this has been a lengthy meeting. Is there anything else for the good of the order? If not, it is 2:44 and we will adjourn the meeting.